Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has already been sworn, Your Honor.
Good morning, thank you. If you could please connect the headset.
The interpreter is connected to this, Your Honor.
Good morning, sir. Please tell me your name.
José Manuel Ordóñez Argueta.
José Manuel Ordóñez Argueta.
21MM 6816. Sir, you're here charged with battery, dating, violence. There is probable cause. I'm going to appoint an attorney to represent you. Does the state object to pretrial release in this case?
Yes, Your Honor, given the allegations in the affidavit, it does seem like potentially as a burg of the structure, the battery therein. I believe it wasn't charged that way due to a line further down in the affidavit. However, that is something that needs to be figured out by the state when we take the charging decision. But given the allegations in the affidavit, the state would reject or object to PCR being placed on him at this time.
Does burglary qualify for pretrial release?
Of a dwelling?
Yes.
Yes, Your Honor.
The only reason, Your Honor, I believe it wasn't is further down in the affidavit, or approximately middle of the affidavit, they say they were in an intimate relationship for 2 years and lived together at the location of residence. He had slept there the night prior. So it does say they're ex-boyfriend and girlfriend. However, it does seem like he was living there. However, that's why I believe it was not a burg with that therein. However, we do have the victim now in the box. I don't know if she is for this case.
Ma'am, do you wish to testify today? Do you speak English?
No.
Could I have the interpreter disconnect from the headset?
¿Me escucha, señora?
Lo escucho.
Ma'am, do you wish to testify today?
Señora, ¿usted quiere presentar testimonio el día de hoy?
Sí.
Yes.
Please raise your right hand to be sworn.
Levante la mano derecha que se va a juramentar.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Jura y afirma que el testimonio que va a presentar será la verdad y toda la verdad con la ayuda de Dios.
Sí, lo juro.
Yes, I do.
Please state your name for the record.
Diga su nombre para que conste en las actas.
María Edith Doroteo Sóstenes.
María Edith Sóstenes. Doroteo Sóstenes.
All right, thank you, ma'am. I'm going to ask if the prosecutor has some questions for you.
Gracias, señora. Voy a ver si la fiscal tiene alguna pregunta para usted.
Yes, Your Honor. Good morning, ma'am. Can you please state your relationship to Mr. Ordona Ortega?
Buenos días, señora. ¿Puede usted decir qué parentesco o relación tiene usted con el señor Ordóñez Ortega?
Éramos pareja.
We used to be a couple.
Are you afraid of him?
¿Y usted le tiene temor a él?
Un poco.
A little.
Has anything like this ever happened before?
¿Y en el pasado ha ocurrido una situación similar?
Sí.
Yes.
Are you willing to call 911 if anything like this ever occurred in the future?
Si en el futuro llegase a ocurrir algo parecido a esto, ¿usted estaría dispuesto a llamar al 911?
Sí.
Yes.
Do you believe drugs or alcohol were involved in this incident?
¿Usted cree que estuvo de por medio el alcohol o las drogas en este incidente?
Sí.
Yes.
Do you recall which one?
¿Sabe específicamente cuál?
Yo sé que él fumaba a veces marihuana, pero siempre lo negaba.
I know that sometimes he would smoke marijuana, although he would deny it.
Okay. Do you believe he was impaired by alcohol during this event?
Y durante este incidente, ¿usted cree que él estaba discapacitado por el alcohol?
Sé que él estaba ebrio, pero se miraba que era consciente de las cosas que hacía.
Well, I know he was drunk, but he was still aware of what he was doing.
All right. Thank you. And do you want to have contact with him while this case is pending?
Y mientras este caso está en curso, ¿usted desea mantener contacto con él?
No.
No.
One more question. Is he living at the same residence with you, or was he living at the same residence with you?
¿Él vive en la misma residencia donde vive usted o vivía en la misma residencia donde vive usted?
Hace unas semanas atrás, él se había ido de donde yo vivía porque la persona que tiene contrato con el dueño del alquiler soy yo. Y ya se había ido porque yo se lo había pedido, pero siempre regresaba.
Okay. Well, weeks ago, he left the house since the leasing contract is under my name, and I had previously asked him to leave, but he, as always, could keep on coming back.
Thank you, that's all I have.
Gracias, eso es todo.
Any questions from the defense?
Defensa, ¿alguna pregunta?
No questions, Your Honor.
No hay pregunta, su señoría.
All right, thank you, ma'am.
Bien, gracias, señora.
Ms. May, did you wish to be heard? You can stay.
Yes, Your Honor. Can we set this for 24 hours, potentially to get other charges added to this affidavit and a new supplement? Given the victim's testimony and the allegations in the affidavit, it seems like it potentially is a burg bat with assault or battery therein, which would be a PBL, and you'd be held no bond.
Es decir, nos da un plazo, su señoría, de 24 horas para nosotros revisar qué otros cargos se van a imputar y un informe de anexo, tomando en cuenta el testimonio que se ha dado y la acusación que hay. Esto quizá califica para lo que es una amenaza durante una intrusión y quizás estamos pidiendo que no se le otorgue fianza.
Your Honor, I
Just a moment. Sir, while you're in this courtroom, you will look at me or you will look at this wall. You don't look at her. Do you understand?
Entonces, está aquí en la sala, usted me mira a mí o mira a la pared, no la esté mirando a ella. ¿Está bien? ¿Entiende? Okay.
All right. Go ahead, Miss George.
Your Honor, I would object. Based on the arrest affidavit, that's what the officer charged here. The state can always bring other charges later on, but for today's purposes, you've already found PC for the battery. I'd ask that you set a bond in this case, and if the state wants to bring up other charges, they can do so later on.
Sí, señoría, yo voy a objetar a lo que acaba de decir la fiscal. Tenemos que ceñirnos a lo que aparece el documento, el affidavit que ya el policía registró instruyendo los cargos. Si la fiscalía quiere presentar otro tipo de cargo, bien puede hacerlo, pero ya se determinó que había indicio de culpa por agresión física. Así que yo pido que se le dé una fianza y si la fiscalía quiere, más adelante, en otra fecha, puede presentar los otros cargos.
Your Honor, I understand defense counsel's argument. If you're not inclined to give us a 24-hour reset, state would just ask for a higher bond than normal, as this is a misdemeanor bad DV. Bond is generally around $500 for this charge. But given the allegations and the victim's testimony, state would ask for a higher bond if you're not otherwise inclined to do a 24-hour reset.
Bueno, yo entiendo el argumento que está presentando la abogada de la defensa y si la juez no está dispuesto a darnos esas 24 horas para reformular cargo, yo pido entonces que se le exija una fianza de más valor, tomando en cuenta que se trata de una falta donde hubo una agresión física. Y también pues sabemos que la fianza viene por eso de $500, pero tomando en cuenta la denuncia y el testimonio, pido que se le exija que pague una fianza más alta.
And Your Honor, I would just point to the fact that his risk assessment is low. I don't see the criminal history on my sheet, but I would just argue he's been here for over a year. He's currently employed. You setting a bond amount and placing him on pretrial release with a no contact order would be sufficient in this case to prevent any further action and also ensure he shows up for court, Your Honor.
Su señoría, lo que pido yo aquí es que básicamente se tome en cuenta de que él no tiene ningún historial, no veo que él tenga ningún tipo de historial. que la fianza sea lo baja. Lo que sí sabemos de él es que él ya tiene aquí más de un año, de que él está actualmente trabajando. Así que es suficiente con que se le exija una orden de prohibir el contacto con la víctima, que se le exija la fianza y que se le impongan las condiciones de libertad provisional. Eso sería suficiente para evitar cualquier otro incidente, cualquier otro problema y también para asegurarnos de que él comparezca a las futuras citas judiciales.
Lastly, Your Honor, one more thing. He's demonstrated that he's a danger to this victim as well as the community. I understand he has limited criminal history, if any. However, he did show up to her apartment and broke in at 3:25 a.m. when the victim was unable to protect herself. So I would argue that he's a danger to the community, even though he has no history and he has a low risk assessment. The allegations in this affidavit are concerning to both citizens of Florida and Orange County, as well as to this victim that we have here today.
Por último, su señoría, queda demostrado que este acusado sí presenta un peligro para la víctima, tal como ella lo constató. Y si es cierto que él tiene poco historial o no tenga antecedentes, toma en cuenta de que él irrumpió en la vivienda a las 3:25 de la madrugada, momentos en que la víctima no estaba capacitada para poderse defender por sí misma, así que aun cuando no haya historial, aun cuando se haya determinado que él sea de bajo riesgo, me parece igual que es preocupante lo que aparece en los documentos y por lo tanto nosotros pronunciamos que él sí presenta un peligro para la comunidad, para la víctima, de acuerdo a las leyes de la Florida y del condado de Orange.
All right, thank you both for those arguments. But at this point, I'm just going to ask if anyone can point me to the rule or the statute. Ms. May, let's start with you. You asked the court to give you another 24 hours. Under what rule or statute?
Si me puede por favor indicar específicamente cuál regla o cuál ley, para que sea más específica, suéname.
Your Honor, under the Florida Rule of Criminal Procedure 3.133, State can ask for an additional 24 to obtain additional information. And that's all I'm asking for in this case is to obtain additional information from the law enforcement officer, as well as potentially the victim, to bring additional charges that would hold this defendant on a much different bond schedule.
Su señoría, según el Código Orgánico Procesal Penal, la ley 3.133, la Fiscalía puede pedir que se dé un plazo de 24 horas para poder obtener más información, para poderle hacer preguntas a los oficiales que hacen el arresto, probablemente también hablar con la víctima y así definir si se van a presentar más cargos que lo pongan en otro tipo de fianza.
Your Honor, it was my understanding that that's only for probable cause purposes.
Su señoría, a mi entender, eso nada más se hace para determinar cuando hay indicios de culpa.
Well, let's read it. A1 says, in all cases in which the defendant is in custody, a non-adversary probable cause determination shall be held before a judge within 48 hours from the time of the defendant's arrest.
One moment. En cualquier caso, cuando hay una custodia, se va a determinar ante un juez si se va a determinar que hay indicios de culpa que justifiquen la detención.
So what time was he arrested?
¿A qué hora lo arrestaron a él?
Your Honor, per this event happening at 3:25, the officer says the date time of arrest was 4:47 a.m.
There it is.
which would have been yesterday at 4:47 a.m.
Sí, la fecha según lo oficial, el incidente fue a las 3:25, pero el arresto lo hicieron a las 4:47 a.m. ayer.
So I read the affidavit. I think it's clear that this is a burglary with a battery. It is also a false imprisonment. It is also an aggravated assault with a deadly weapon. I mean, there's multiple charges, some of which are life offenses in this affidavit.
Sí, al yo leer este affidavit me queda muy claro que esto fue una intrusión con fines ilícitos, donde hubo una agresión física, donde hubo una detención ilegal, donde hubo una amenaza agravada, así que hay múltiples cargos que incluso pueden acarrear la cadena perpetua.
Probable cause exists for all of those charges.
Y hay indicios de culpabilidad en todos esos cargos.
So I don't actually know which one of you is correct in your reading of this rule.
Realmente no sé exactamente cuál de los dos tiene razón al leer este reglamento.
I'm unsure, Your Honor. I'm just pointing to the extraordinary circumstance, and given the charges that could be pending against him, given that they have been deemed PBL by the legislator, state would contend that it is extraordinary circumstance.
Hay que tomar en cuenta aquí la circunstancia de los cargos que están pendientes, la naturaleza de esta falta.
Your Honor, I would argue, again, I would object. There's probable cause that has been found. We're not holding him for PC purposes. We're holding him on charges the state could potentially bring up in the future. I would ask that we not hold him for an additional 24 hours so the state can add more charges to his, on his case, Your Honor.
Señoría, lo que está pidiendo este plazo de 24 horas no es en sí para determinar culpabilidad, sino más que todo para la Fiscalía constatar si va a presentar más cargos.
In addition, Your Honor, I would just point out that we have cases all the time where additional charges could have been added and they have not, and we do not hold the defendants here for an additional 24 hours so the state could add charges.
Y le digo a su señoría que aquí hemos tenido otros casos en los cuales se ha debido, pero no se imputó los cargos que fueron debidos y que el acusado no recibió los cargos que le correspondían.
Your Honor, in response to that
Okay,
argument-
hold on. I think I'm done hearing argument. I get both sides. I understand what you're both arguing. What I want to know is, what does the rule allow or require, and what does the statute allow or require?
Lo que quiero saber es que el reglamento creo que permite y qué es lo que requiere, porque ya escuché ya ambos argumentos, ya escuché suficiente de ambas partes.
Because there is probable cause for a life felony and several other felonies here,
Como hay indicio de culpabilidad para un delito grave que acarree cadena perpetua y otros delitos graves,
I don't think it's unreasonable to give the state extra time to make that charging decision.
creo que no es irracional que se dé más tiempo a la Fiscalía para que tome la decisión de los cargos que va a presentar.
However, given occasionally we have 50 motions to release someone on their own recognizance because the state hasn't made a charging decision for over 30 days, I don't have a whole lot of confidence that your office is going to make this decision in a few hours, Ms. May.
Ahora, lo que sí creo avisarle a la señora May que a pesar de todo esto, hemos tenido a veces hasta 50 casos en los cuales se le da el plazo a la Fiscalía, pero la Fiscalía no presenta los cargos a tiempo, se tardan demasiado. Y yo creo que la oficina de la Fiscalía, señora May, no va a completar eso en este tiempo.
Your
So what
Honor,
I'm going to do is give you until 1 o'clock today to make a decision.
Lo que va a hacer es que le va a dar hasta la 1 de la tarde a que tome la decisión.
Your Your Honor, that would be on the officer to add those charges, not on the state to, and to get us that affidavit.
Eso, su señoría, sería hasta que podamos conseguir ese affidavit nada más.
No, it wouldn't. The state of Florida files the charges. You could file an information today charging him with a life felony.
No, la fiscalía presenta los cargos. Usted puede hacer la acusación acusándolo a él de una infracción que acarree cadena perpetua.
Your Honor, I could also get the officer to just add additional charges to the affidavit instead of the state making a charging decision when all we have is the affidavit at this time. We don't have body cam, we don't have victim statements, and that wouldn't come in a case package until at least a week. So the state would not be able to make a formal charging decision solely from one affidavit on a life felony case.
Sí, para este tipo de casos se necesitaría algo más que el simple affidavit de la fiscalía. Se le puede pedir al oficial de la policía que ellos presenten más cargos y si no, pues lo que también se puede hacer es permitirnos a nosotros que hagamos todo lo que es el testimonio de la víctima, la cámara que llevan colgado a los policías y realmente el paquete completo se va a tardar hasta una semana.
So what your office will do is different from what the law requires and allows. Your office can absolutely make a charging decision with this information, and you have a victim standing right here.
Bueno, lo que le permite es diferente lo que se le permite a cada organismo, lo que es a la fiscalía. La fiscalía puede tomar una decisión en cuanto a la acusación que va a hacer. Y usted tiene la víctima justamente aquí también presente.
If you want a 5-minute recess to get someone from your office to come meet with the victim, take her down to your office, you guys can take sworn testimony from her. I'll give you that. And then we'll still come back with him at 1 o'clock. If you have the officer with the supplemental report, or if the state wants to make a filing decision by then, we'll hear this again at 1.
Le puedo dar el receso de 5 minutos para que tome la declaración de la víctima que está aquí presente bajo juramento. Y volvemos otra vez a la 1 de la tarde, a ver si ya tiene usted el anexo y puede incluso hacer su decisión de la acusación que va a presentar.
So I'll see you at 1 o'clock today.
Lo veo no a las 1 de la tarde.
Ma'am, please have a seat in the waiting room. Don't leave.
Señora, por favor, siéntese en el área de espera, no se vaya.
All right, let us do the other, do we have other Spanish cases? Oh, that's the only one? Okay. Okay, thank you, that's all we have for Spanish this morning.
You're welcome, Your Honor.
All right, do you want a 5-minute recess, Ms. May?
I'm in contact with someone, Your Honor, I don't need it.
All right. On the line. Who is that? This one? Constant? That's not it. Yeah, it's not this one. No, that's the one that I just did. Yes. How do I get the signed interpreter, though? They just show up? I don't have to call video conference.
Welcome to an Econo meeting. You are entering the meeting now.
No one's, there she is.
Hello.
Good morning, Madam
Judge.
Interpreter.
Good morning.
They're moving the screen now so he can see. Has the interpreter been sworn?
No, Judge.
Go ahead.
Do you solemnly swear to translate from American Sign to English, from English to American Sign to the best of your ability?
Yes, I do. Julie Malassa, nationally certified interpreter. Your Honor, could the defendant move closer to where the deputy is standing with the screen and the screen off to the side?
All right, just a moment.
He's too far for me to see his hands.
All right, they're moving the screen now. Let's see.
Well, the defendant needs to come closer because I can't see his hands. He's too far away.
Right, yeah, we just give him a minute.
Oh, sure. I'm sorry. Okay.
No worries. All right, sir, can you see the sign language interpreter?
Can he come a little closer, please, Your Honor?
Yes.
And if the screen could be moved a little bit to the side so I can see his hands.
All right, sir, can you see the sign language interpreter now? He's not answering, so I don't know if he can't see you.
I need to write. I need to write.
So does he?
Give me a paper to write with.
I don't have paper. Hold on. Does anybody have blank paper?
Notebook paper.
It doesn't seem he knows sign language.
All right, let's see if he writes. I don't want to disconnect from you yet, just in case we.
Oh, no, it's fine. It's fine, sure.
I need to know his name. No, I need him to tell me his name. Well, just hit him in
Just
the
write
paper and
name
see
with a
what he
question
writes.
mark on the paper. Just write name with a question mark on the paper.
Yes. Did you write name? Did you write name question mark on the paper?
Yes, ma'am.
So I don't know if he can read it.
Your Honor, you just wrote OMA. I don't know what that means.
Okay, so can the sign language interpreter ask him in sign if he needs, oh, she's gonna write. Hold on, let's see.
Well, he'd have to come closer. Well, he's writing something.
I believe this is Osmar Despain. This is case number 21 CF 12804. I'm going to appoint an attorney to represent him. can you read what he's writing, Ms. George? Yes.
This is a supplemental disposition, so it's not necessary to move up the date. Okay, and can we have, I'd ask that the state file an amended case plan so that so the case plan can accurately reflect what the case plan tasks are for the filer. Moving further. Your Honor, just to be clear, the jail on October 27th is not being, the jail would not be October 27th, we're keeping the December 8th date, correct? That's correct. Thank you. Ms. Whitehead, is there anything further as it relates to your client and his appearance at future hearings?
I don't believe so, Your Honor, as long as we know that it's December the 8th and that the father is still in jail, we're going to need that. For him to appear for that hearing.
Right, if you'll just provide me with the paperwork to sign.
All right, we're going to try to have the attorney write something for him. We're going to try to determine if he can hear or if he can sign or if he can only write.
All right.
Ms. George, are you able to determine if he can do sign language?
Can't.
He cannot? All right, then I think we're going to disconnect from you, ma'am, because I don't want to keep you holding if we can't use you.
All right, sure. I mean, I'm happy to help with gestures or something, but sure.
Okay, well, then I'll keep you another 5 minutes. Let's just see how
Sure,
far we get.
absolutely.
I don't want to
Absolutely.
keep you out of another courtroom or something.
You're not keeping me out of another courtroom.
Okay, good. All right. And thank you for your patience. I just want to make sure we can.
Was he able to write his name?
Yes, he did confirm it is, in fact, his
Okay.
name. I spelled it out. He does not do sign language. He stated he can only write. I asked if he could hear. He just did this.
So he can hear a little bit?
I asked if a hearing device would help, but I don't think he understands what that means. He just pointed to.
Just do this.
I did.
He's shaking his head no.
Yeah, I don't.
Okay.
So I did confirm that is his name. He did say yes.
Can you ask him if he has ever been diagnosed with any mental health issues? Sir, can you hear me now? Can you hear me at all? No, he can't. I don't think that. The attorney has some mental health concerns based on the things that he's writing. And so I want to make that determination.
Well, you can point to his head, like he did this, for whether he could hear or not. You can point to his head and do the same thing.
Okay. He said yes.
Okay.
I'm gonna see if he'll write it.
Write short sentences.
So I'm going to ask the interpreter, because you're the expert here. I need to advise him what he's been charged with and that I've appointed an attorney. Do you recommend that I write that for him?
I would recommend police arrest you, because I don't know if he understands charge. Police arrest you and then the reason.
Okay. Thank you.
What is the charge?
First-degree murder.
You kill someone.
Thank you. Can you hand him this?
You might want to go ahead and put bond amount on there as well, so he has it all in one place.
I'm going to do this first, and then I'm going to write some more. But good idea. Thank you. Takes a team between all of us. Maybe we'll.
Yeah,
I just want to make sure it's as meaningful for him as possible.
of course. Yeah, we had a case with a man who spoke only Arabic, sign language, and so we made that work somehow.
Wow.
Yeah, we had an Arabic spoken language interpreter and me. I gestured, she wrote. Got it done.
You're,
I see him shaking his head when he read what I wrote.
so, he does, he's pointing at the document he wrote. I am not, I would object against that being turned over to you only because I think that, there may be some facts in there that
Okay, so
all
you,
over the place, so I'm not gonna have him turn it over to you.
that's fine.
However, I will note that there is, I have even more concerns now based off of, the end of his statement.
All right, so here's what I'm going to do. I've appointed your office to represent him. Based on this charge, at this point today, there is no bond. I think that I'm going to ask you to make some notes and get in touch with your colleagues right away to get someone down here to see him and also have him evaluated if you have those concerns, because I don't want him sitting and not understanding why. But I'm not sure there's much point in keeping him in the courtroom today.
Yes, I understand.
So is there anything else you think I need to write for him?
No, he
Well,
understands.
he understands the no bond?
I haven't said that
Not the
yet,
bond yet. He understands what you put here. He's just pointing to,
what he's writing.
he's talking about food stamps right now. So it has nothing to do with it.
Okay. Well, okay.
All right, can you give him this, please?
Deaf people communicate in a circular way, not a linear way. And so that food stamps thing might, in his mind, be connected to the charge, but
It might be.
yeah.
The victim is, I think, based on the affidavit, maybe a homeless person. So maybe there's a connection, and that might be how the food stamps are connected. But I don't want him talking about the facts of the case this
Right.
morning.
What did you write, Your Honor? No bond?
I wrote no, what did I say?
No bond.
No bond. An attorney will come visit you.
I'm just gonna.
Okay.
He,
So if he doesn't understand no bond, you can say cannot pay to get out of jail. Have
Okay.
to stay in jail. Something like that.
Yep, that's what I'm saying.
Okay, so the attorney wrote that for him. No, it's not an order. I was just trying to help him understand. The no bond and the appointment is what needs to be there. And then what's the best way to communicate to him that his hearing is over now and he needs to go back to where?
Police will take you back to jail.
Okay. Can I have one more piece of paper? I'm so sorry.
Police will take you back to jail. Wait for lawyer.
Thank you.
Okay.
Wait, give him this piece of paper so he understands that that's what I'm telling him. I also wrote on one of the piece of paper that I am the judge, so he understands
Oh, good.
I'm telling
Okay.
him this. I don't know if he does, but I'm trying.
Okay.
Yeah, good job. Yeah. Thank you, Madam Interpreter, and thank you for your patience this morning.
Oh, of course. I'm sorry I couldn't help more, but hopefully he understands enough.
Yes. All right, I'm going to turn this off now.
All right.
We're
Thank you,
waiting on
Judge.
Creole. Thank you, ma'am.
Bye-bye.
That paper.
Mr. Got it, okay. Do I call the Creole, or are you connecting me? Okay, no. Well, it has been a Monday morning, guys.
Right.
Oh, do that, and Creole will answer? Usually what they do.
Good morning.
Good morning, this is Judge Gibson. I'm holding for a Creole interpreter.
This is the Creole Interpreter.
Excellent. Just one moment. I think we have the wrong person.
Okay. Oh, okay.
Oh, has the interpreter been sworn?
I have not.
Please raise your right hand.
Do you solemnly swear to translate from Haitian Creole to English, from English to Haitian Creole to the best of your ability?
I do. Isabel DeRocha, Code Interpreter, Creole.
All right. Ma'am, please calm down and tell me your name.
Madame Kijan Aurélé, s'il vous plaît, et puis calmez-vous. The interpreter did not get that.
Okay, ma'am, I need you to take a breath and calm down, and then tell me your
Okay.
name.
Madame, on besoin de prendre sang pour nous capables d'entendre ou bien. OK, prends sang et puis dis-nous qui Jean Aurélé. My name is Rafalda. The interpreter did not quite get that. Sorry.
It's Mafelda Constant,
Mafalda Constant. Okay.
21 MM 6818. Ma'am, you're here charged with battery, domestic violence.
Madame ou accusée de attaque, violence domestique.
I'm going to appoint an attorney to represent you.
Libre albo un avocat pour représenter ou.
There is probable cause.
Qu'il y a assez évidence.
Now, let me ask, sir, do you wish to testify and do you need the interpreter?
Monsieur, est-ce que vous voulez témoigner? Est-ce qu'on a besoin d'interprète?
Yes, oui.
Yes.
Please raise your right hand.
Levez main droite ou.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Est-ce que vous sermentez que témoignage va bailler la vérité, toute la vérité, rien que la vérité devant bon Dieu?
Oui.
Yes.
Please state your name for the record.
Qui Jean Aurélé?
Wilson Garçon.
Wilson Carson?
I'm going to allow the prosecutor to ask you some questions.
Le procureur l'État pour poser quelques questions.
Good morning, sir. Can you please state your relationship to Miss Constant?
Monsieur, qui est souillé pour Madame Constant?
Madame moi.
She's my wife.
Are you afraid of her?
Est-ce qu'on peut lire?
Non.
Non.
Do you believe drugs or alcohol were involved in this incident?
Est-ce que vous pensez soit drogue ou bien alcool et fait que bagarre ça t'est arrivé?
Non.
Non.
And do you want to have contact with her while this case is pending?
Pendant que cas ça est à passer dans la justice, est-ce que vous voulez gagner contact avec madame là?
Oui.
Yes.
All right, that's all I have. Thank you.
OK, il n'y a pas d'autres questions.
Any questions from the defense?
No,
Est-ce que défense a une question? Non.
Why does she not qualify for pretrial release?
Oh, no, she could qualify. I believe they left a note that she was a possible PTR candidate. It's just her APHIS didn't clear at the time, but she can qualify.
Okay.
OK. Madame, vous êtes capable de qualifier pour relâche avant procès?
Ma'am, I'm going to place you on pretrial release.
Nous pouvons le mettre dans relâche avant procès, madame?
With special conditions, you can only have peaceful contact with the victim.
Avec conditions spéciales, ou capable de gagner seulement bon contact qui en paix avec victime là.
That means no hostile contact.
Qui veut dire ou pas capable de gagner aucun mauvais contact ensemble avec lui.
Non, nous pas de problème. C'est une seule fois, première fois nous avons des problèmes.
No, we never have any problem. It's the first time that we have any kind of problem like that.
All right. You cannot possess a weapon of any kind, a firearm or ammunition.
Ou pas capable de gagner aucune arme de n'importe quelle qualité, ou pas capable de gagner arme à feu, ou pas capable de gagner aucune munition.
Any other conditions the state would request?
Est-ce que quelles conditions que l'État a demandé?
No, Your Honor.
Non, juge.
All right. Thank you, ma'am. Good luck.
Merci, madame. Bonne chance.
Thank you, sir, for coming. Good luck.
Merci, monsieur, pour venir. Bonne chance.
Your Honor, was a PD appointed?
Yes, I appointed the PD. Did I? Yes.
Is that the only Creole Interpreter case?
Is that? Yes, that's all. Thank you.
All right. Thank you. Bye-bye.
Bye. That was different. Usually we don't do that, but she was actually on the screen. So that's better, I think, because they can see her. Oh. Boy, that's too bad, because I think that was great. For a second, I didn't understand why he kept looking, and then I saw her, and I was like, oh, that's fantastic, because he's watching her. We're ready.
Your Honor, McClish is a refusal.
All right. The PD was appointed in this case. But I'm confused as to why this person is here. Is he just here on the misdemeanor?
No, Your Honor. He has a life felony as well as F1s, F2s, and F3s.
Why was he reset?
He refused on the 26th as well.
Yeah, so he's a right to be here, but he can waive that right. So I'll find his refusal a willing waiver of his appearance today. I did review the probable cause affidavit. There is probable cause for these charges.
Your Honor, I'm going to argue no PC.
Oh, wait.
Sorry.
Go ahead. Which one?
Attempted homicide on Aaliyah. Based on the reading of the arrest affidavit, it states that the reason they charged him with an attempted homicide on Aaliyah was because of the gouging of his eyes. Your Honor, I would argue that there is nothing to show that gouging someone's eyes out is enough to commit an attempted homicide. When I went back to do some research on gouging of eyes out as an attempted murder, the only thing that I could find, Your Honor, was that in a similar case where the defendant broke the officer's leg, he was charged with an aggravated battery, and then he gouged the officer's eyes out, and again, he was, it says that constituted a battery on a law enforcement officer. He has it looks like they separated the charges for the offense where he hit the officer with a brick. However, the officer stated based on his training, gouging of the eyes is a technique known to be a deadly force method, and it is capable of killing a human being. However, I would argue, Your Honor, that this was a struggle when he was fighting with the officer. The officer had him in a headlock, and he poked him in the eye to get out of that headlock. So I would argue there's no PC for an attempted homicide on a law enforcement officer on count 2.
Your Honor, in response to defense's argument, I understand that was her reading of the affidavit. However, I do believe the officer did intend that also the brick and hitting the officer in the head with the brick could also qualify some of the facts to substantiate the attempted homicide on Leo, the PC.
That was already charged on a different officer, Your Honor.
Okay, wait. So on page 4 of 6, it says toward the bottom, due to the fact that the defendant attempted to kill Officer Hurt from a premeditated design to effect his death with a weapon.
The brick.
That's one. And then the second one is, due to the fact that defendant attempted to kill Officer Zambito from a premeditated design to effect his death. That's 2. Is that the one that you're arguing is not?
Yes, Your Honor.
Okay, hold on.
It's confusing because there's so many officers, but.
Right, because I
look
I missed what you said, so I got to go back and reread that again.
So if you look at page 3, it looks like it's kind of the middle paragraph where it states, I spoke with Officer Zambito. If you read this is where the eye gouging occurred.
Oh, yeah, I see that.
And then if you go further down, that's where he states, due to my training as a police officer, an eye gouging is known to be a deadly force method.
Your Honor, the only case law defense was able to produce was an unrelated injury, a broken leg, which arguably, I guess, could affect death if was done in a certain way. However, in this case, we do have eye gouging, biting, and I believe he had a laceration also to his bottom lip. State would contend that it would be enough to potentially affect officiated death upon the law enforcement officer due to the sensitive nature of your eyes and the approximation to your brain and other important body functions.
Your Honor, and again, they've already charged him with aggravated battery on a Leo with great bodily harm, aggravated battery with a deadly weapon, attempted first-degree murder of a Leo with a weapon, which was the brick. Again, I'm arguing the attempted homicide on a Leo, and he states it's for the eye gouging is not enough to charge someone for attempted homicide by just gouging out your eyes. And again, I reference the case, it even states, the less severe attack in which he tried to gouge out the officer's eyes.
Do you have that case can I read it? Thank you.
You're welcome.
Got it?
Thank you, ma'am. So it's a first district Court of Appeal case from 1989. Is there any?
The only thing was they changed the conviction. They decreased the sentence, Your Honor.
Wow, it's a pretty violent attack. All right, so after reading this case, which is State of Florida versus Whidden, 539 Southern 2nd, 586. The first DCA was deciding if the defendant could be convicted of both aggravated battery. Hold on, I gotta find that statement again.
And battery on a law enforcement officer.
Oh, and battery on a law enforcement officer. So I see that I see where you're talking about where the court says in the, quote, less severe attack in which he tried to gouge out McLeod's eyes. But that's basically dicta, right? It's not relevant to the holding of the case. The holding is whether he could be convicted of these two charges at the same time. And the court's holding is that he could be because it was two separate transactions. They distinguish an act from a transaction. So
Your Honor, that was state's argument from the last 3 paragraphs.
yeah, I think that you might have an argument later, at a later stage, Counselor, but I think there's probable cause in this case because while I am not familiar with defense tactics, in the affidavit, it says the law enforcement officer is, and this is a method of deadly force capable of killing a human being. So I don't think we have enough information to know if the dicta in the Whidden case is the same type of attack that was in this instant case. So I'm going to find there's probable cause, but like I said, you might have a great argument at a later stage. Do you need this back or can I keep it? Okay, I'm going to keep this case then. So he'll have no bond on counts 1, 2.
Your Honor, he's entitled to bond on 2 through 8.
So just 1?
Just 1 is a life offense, so state would ask for no bond on that one, and bond on 2 through 8. Count 2 is an F2, count 3 is an F1, count 4 is an F1, count 5 is an F3, count 6 is an F3, count 7 is an F3, and count 8 is an F3.
All right, on count 1, it's no bond. On counts 2 through 8, I'm going to set monetary bond, but the conditions are going to all be the same. No weapons, firearms, or ammunition, no victim contact. Not return to this scene. Where did this occur, Ms. May?
It was at the intersection of North Magnolia Avenue and East Washington.
And he can't use Facebook while out on bond. On count 2, his bond will be $500,000. On count 3, his bond will be $100,000. Count 4, $100,000. Count 5, $50,000. Count 6, $50,000. Count 7, $10,000. And count 8, $150,000. And I did appoint the PD. Is that misdemeanor case a case? Yes. That he's being seen on today?
Yes.
All right, hold on a second then. Let me get out of this one. This one is 21 MM 6824. Again, Ms. George, I'm going to appoint your office.
Yes, Your Honor.
I don't understand. It's from the same transaction.
It is, Your Honor. State would just ask that you treat it as a subsidiary.
All right. All right, his bond will be $100 on that. No weapons, firearms, or ammunition.
Mr. Mott, Your Honor, is refused.
21 CF 12788. Ms. George, your office was previously appointed.
I'll waive the appearance, Your Honor.
Your Honor, I have notes, this was the judge over the weekend was not able to obtain PC. However, state would contend that the defendant was the driver and sole occupant of the vehicle. The vehicle was reported stolen one day before it was found, and the defendant was in possession of recently stolen property as the sole driver of that vehicle, which is sufficient for PC for a grand theft motor vehicle.
I don't know.
Was this hot pursuit?
I'm sorry?
Was this hot pursuit, or was it
Law enforcement.
the day
ran-
after?
It was the day after, Your Honor. Law enforcement ran the tag, saw it came back stolen from OPD jurisdiction. Given that the time frame is not far removed, given that he's in possession of recently stolen property, we can ascertain that he stole the motor vehicle.
What are the elements of grand theft?
The intent to deprive the owner.
A person commits theft if he or she knowingly obtains or uses or endeavors to obtain or use the property of another with intent to either temporarily or permanently deprive the person of the right to the property. And then obviously if it's a vehicle, it's a third-degree felony.
Knowingly and then unlawfully obtaining or using it.
Your Honor, under that same statute, 812.022 sub 2, and in the Florida jury instruction, proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Given this is a one-day indifference, it's not far enough removed that he shouldn't have known, and he wasn't able to satisfactorily explain why he was in possession of a vehicle that had been reported stolen.
Your Honor, I would argue he did not know. There's nothing in this arrest affidavit that shows he knew or should have known the vehicle was stolen. It just states a teletype confirming the vehicle was stolen. Other than that, we have nothing.
That's exactly what the statute says, Your Honor. It gives rise to that inference that they should have known. That's exactly what the possession of recently stolen property inference gives the court, if it's within a certain amount of time.
Right, if
It's
not
an inference of
satisfactorily explained.
It doesn't.
And he did not, he made the decision not to speak to law enforcement and satisfactorily explain, therefore that inference is against him.
I would just argue there's not enough information in here for us to determine anything, Your Honor. He's driving the vehicle, allegedly it's reported stolen, but other than that,
Yeah, I'm going to find probable cause, but Ms. George, I think you guys have a great motion for later. But the fact that he's in possession of recently stolen property, and it is not satisfactorily explained, I think there's probable cause. I show he's a violent felony offender of special concern. He might actually be on probation. He was just convicted of robbery earlier this year. Is he on probation for that robbery?
Yes, yeah.
Is there a violation of probation?
Just a hold, just the VFOC hold.
All right. His bond is $5,000, no victim contact.
Myrick, Your Honor, his behavior.
21 MM 6809. I don't know why this one was reset either. Does anyone know?
Myrick, I have it reset for, I believe I looked it up.
The PD was appointed. But I don't know why that would, we wouldn't reset it for that. She did set bond? Because then why is it reset?
I just have that his prints were not cleared on the court minutes as well as on the first appearance information sheet.
All right, I'm revoking his out on bond case and appointing the PD in that case as well, just in case you weren't.
So I'm looking at the court minutes and nothing was checked as to whether PC was found or not, or if bond was stayed. It's just blank, the whole first page.
So she didn't find probable cause. Maybe it's about his name because it says Doe. There is probable cause. All right. I find there's probable cause, but she set the bond, right? No?
No.
All right, I'll stay the bonds.
Small.
It's a rough morning.
Smalls' refusal, Your Honor.
21 CF 12791. Ms. George, your office has already been appointed, but I'll find his refusal a willing waiver of his appearance today. Does anyone know why he was reset?
The notes I have is she didn't know what the two prior convictions were. State would just point to the last paragraph that he was found guilty 3/22 of 2019 of petty theft with two priors,
Yeah, I saw that.
which is sufficient for PC as to
Right.
that charge.
All right, there's probable cause for that as well. I'll stay the bond. The PD was appointed, and I'm revoking his out on bond.
Your Honor, state would also ask for a no return.
An order no return.
Thank you.
Please tell me your name. You're here in 21 CF 12766. An attorney has already been appointed to represent you. Does anyone know why this was reset?
The notes I have from the ASA covering this weekend was no PC on count one. I believe the issue upon reading the affidavit, since it says he pulled a gun, said he was going to kill her, he has a gun. I believe there is ag assault with a deadly weapon. I believe the officer charged incorrectly with the attempt, potentially is the problem. However, his intent, according to page 3, is ag assault with a deadly weapon due to the officer's own affidavit. I believe it incorrectly came through as an attempt. However, it is charged correctly as a 78402.
Is attempt an inchoate crime of assault? I feel like,
That's not what I had. I had that, it doesn't, I don't have any notes for this case. It just said the rest of the resets were refusals. So I'm not sure why this one was reset.
I have no PC to count one. I can check the court minute.
Yeah, so if they
But
didn't,
at the top of the face sheet, it just says count one state to provide additional supplemental report, like a supplemental report.
oh,
I don't have anything.
thank you.
The court minutes also advise the bond was stayed, however, it says, probable cause as to 2, 3, and 4, reset for 24 hours as to count one. I think potentially the issue was the offenses came through as an attempt ag assault, when it should have came through as just an ag assault with a deadly weapon.
Yeah, I think there's probable cause for aggravated assault. The allegation is that he pointed a weapon at her and said, if you don't get out of my house, I will kill you, while pointing a Glock 45. So I think that's probable cause. Thank you.
I'm trying to make sure we have a correct statute.
Yeah. I also show he's a violent felony offender of special concern and may also be on state probation already because he pled to it says trespass, domestic violence, VTR, interstate. Do you know what that means?
It's interstate
Interstate
probation,
compact.
so
But I mean, it's 2 years of probation on a trespass, so that's odd. Yes, ma'am, Ms. George.
I don't,
They took the car. She showed the
there-
police the gun. Like, they released the car and everything.
he's stating that the reason that there was no PC was because the victim came here and stated that that did not occur, Your Honor.
Respectfully, PCs found from the four corners of the affidavit, so at
Yeah.
this time, the affidavit has to be read. And I don't have notes regarding the victim being here or not. For Madam Clerk, the correct statute for the ag assault with a deadly weapon is 784.021, sub 1, sub A. It was previously charged with a sub 11, just take off the 11.
Yeah, so the court minutes do not reflect that the victim appeared and testified, so I don't know where. Right. It shows that he wasn't here, and there's nothing about the victim appearing. So I don't know anything about that, but there is probable cause. I read the affidavit.
Your Honor, I believe the conditions were no contact with the victim, maintain separate residences, and no weapons, firearms, or ammunition.
Yes.
You're just going to maintain all those?
Yes.
Okay, thank you.
All right, sir. Since you weren't here yesterday, I want you to hear this. The judge previously ordered, and I will also order today, you're not allowed to have any contact with a victim. Do you understand what no contact means? You can't call her on the phone, you can't send a text message, you can't communicate through social media, you can't send a message through friends or family. There's no contact at all. You can't possess a weapon of any kind, firearm or ammunition. Was this firearm confiscated, Miss May?
1 second, Your Honor.
I don't actually recall reading that.
Don't either.
Okay, calm down. It doesn't matter for today's purpose. I understand what you're saying. Your Honor, the victim has the gun. I believe it's in there.
It does say she walked out with the gun, right?
Well, it's
Yeah.
stated that it's also her gun,
Yeah.
so I don't know if law enforcement would have obtained it.
All right. Sir, I'm going to give you 24 hours to surrender any other firearms you have to law enforcement. You can't be within 500 feet of her residence. I'm also going to order that, or her place of employment. Do you understand? Did you say yes? Thank you. Your bond on count 1 will be $10,000, and I'll stay all the others. Good luck, sir.
So it's 10,000, 3,500, 500, 1,000?
1,000, right.
All right, thank you.
But he might have a VOP coming, so. Please tell me your name.
Hamza Moore.
21 CF 12815. You're here charged with aggravated battery on a pregnant person. There is probable cause for that charge. I'll appoint an attorney to represent you. Does the state object to pretrial release in this case?
No, Your Honor.
Ms. George, is that what you'd like for your client?
Yes, Your Honor.
All right, so I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
I'm also going to require that you post a monetary bond. However, I'll reduce that amount to $1,000. Were you two living together?
Yes, ma'am.
All right, you cannot now. I'm going to order that you must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings, but after that, you cannot go back. Do you understand?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must comply with any plan set in place by DCF. You can have no unsupervised contact with any minor child under the age of 18. Do you understand?
Yes, ma'am.
All right, good luck, sir. Sir, please tell me your name.
Timothy Lamar Hart.
21 CF 12800. You're here charged with aggravated assault with a weapon. There is probable cause. I'll appoint an attorney to represent you. Hold on one moment. In this case, your bond will be $3,000. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
I'm sorry, I couldn't hear you.
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. Were you two living together? You cannot now. I'll order you must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes.
All right, good luck. Please tell me your name.
Kelly Dawson.
21MM6827. You're here charged with battery domestic violence. There is probable cause. I'm going to appoint an attorney to represent you. Good morning, sir. Did you wish to testify?
Yes, ma'am.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am, I
Please
did.
state your name for the record.
Jeffrey Engelbrecht.
I'm going to ask if the prosecutor has some questions for you.
Good morning, sir. Can you please state your relationship to Miss Dawson?
Girlfriend?
Are you afraid of her?
No, ma'am.
If she were to be released from custody today, would you be afraid of her?
No, ma'am, I would not.
Do you want to have contact with her while this case is pending?
I would like to, yes, ma'am.
And has anything like this ever happened before?
No, ma'am.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
I would, ma'am.
And do you believe drugs or alcohol were involved in this incident?
Alcohol was, yes, ma'am.
All right, thank you. That's all I have, Your Honor.
Ms. George, anything from the defense?
No, no questions, Your Honor.
All right. Does the state object to pretrial release?
No, Your Honor, given the victim's testimony here today.
All right, Ms. Dawson, I'm going to place you on pretrial release, and based on the testimony here today, I'm going to allow you to have peaceful contact with the victim. Do you understand what peaceful contact means?
Yes, ma'am.
No hostile contact, no raising your voice, no shoving, no hitting, nothing like that. You understand?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. You understand?
Yes, ma'am.
All right, good luck, ma'am. Good luck, sir. Thank you for coming.
Thank you, Your Honor.
What happened to Jorge Morales? We skipped him. All right.
I have him, Your Honor.
We'll check it after this one. Sir, please tell me your name. 21MM6811. Mr. Given, I need you to look at me while you're in the courtroom. Do you understand?
Yes, ma'am.
All right, sir, you're here charged with assault, domestic violence. There is probable cause, and I'm going to appoint an attorney to represent you. Ma'am, did you wish to testify this morning?
Yes.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Jackie Pina.
Go ahead, Miss May.
Good morning, Miss Pina. Can you please state your relationship to Mr. Given?
I'm his girlfriend.
Okay. And are you afraid of him?
No.
Do you want to have contact with him while this case is pending?
Yes, but it's some kind of misunderstanding. If you read the police report, I don't know how I became the victim.
Ma'am, I can't hear you. I need you to get closer to the microphone.
It's been some kind of misunderstanding. If you read the police report, I don't understand how I became the victim.
It says, Jackie informed me that Victor, her boyfriend of 4 years, came home after being out drinking all day. He was quiet at first, but then started arguing with her, questioning if she was cheating on him. While arguing, Victor grabbed a knife from the kitchen tray and waved it around in an angry manner. So that's the aggravated assault, and that's why you're the victim.
No, ma'am. He was fighting with another guy. The guy grabbed the knife and put it to his throat. He called the police.
And Your Honor, I would argue no PC.
He called the police.
For an assault. They have it as an assault. It states that he's waving the knife in an angry manner. Family members grabbed the knife and started pushing Victor out of the house, at which time he stated he was going to kill somebody.
I don't know who
But at
wrote
the
this
time,
report.
there's no
Did I write
threat.
or sign anything?
Made directly to anyone with the knife in his hand. So I don't know. I don't see the.
Confused.
I think, so the reason, hold on one second, ma'am. I'll tell you why I initially found probable cause, because it says that while arguing, he grabbed the knife and was waving it around in an angry manner, and then other family members pushed him outside. So the way I'm reading that is they're in an argument, he's waving the knife, it would be at her that he's waving the knife. So that's the threat. I don't think you have to couple that with, I'm going to stab you. I think if you're waving a weapon, that's an assault. But
I apologize, John.
sorry, hold on. I wanted to hear what Miss George,
ma'am.
she's the public defender, and I appointed her in this case, so I wanted to hear her argument.
Yes, ma'am.
That's why I was telling her why I initially found probable cause.
Yes, ma'am.
But
Your Honor, state would just contend that
Yeah.
it's by word or act. In this case, state would argue that it's by act, due to being during an argument and in an angry manner. So
Right.
there has to be coupled with words to substantiate the ag assault.
But before we get back to you, Miss Pina, give me one more minute. Miss George, was there anything else that you wanted to argue on that?
No, Your Honor.
Okay, ma'am, what else did you want to tell me? I'm sorry, we had to do all of this
I
discussion.
was confused because it wasn't me. It was him and the guy fighting in the house. The guy had the knife to his throat. He called 911. And then all of a sudden, I know he was being charged with me. I'm like, how did I get in the middle of this?
Do you know who the other man was?
Yeah. it was,
That's not listed in the
my
police report.
nephew's friend.
It states,
Your Honor,
He put
it
the
states
knife
in
to
the
his
beginning,
throat.
Your Honor.
It states that the defendant called 911.
Right, but it doesn't say who the other person is.
Yeah, because we don't know the guy's name. We told the officers we didn't know the guy's name.
I see.
So the officer asked what it started over, and I said, well, him and the guy was arguing because he thought that I was flirting with the guy. So they were fighting. The guy had the knife to his throat. He called the police.
I did read that.
And then next thing you know, I was the victim. Because they were asking me questions on how long we've been together.
Your Honor, I think
They asked me, did I want to write a statement? I said, I wasn't fighting with him. The guy was fighting with him.
I believe it's also stated that he was going to kill someone. And given there were multiple people and he was waving it around in an angry manner, it wasn't directed towards a single person.
They have her as the victim though.
Yeah, that's why I got confused. Like, we asked him in there. I wasn't fighting with him.
Jackie Pina as the victim.
Yeah, that is what it says.
And they said that I told them that I said, no, they never asked me that. It was just me and my son standing there. And they should have had me write a report or something. I'm saying, where this information came from? They had me sign nothing or write nothing.
Your Honor, I understand there's enough for probable cause, but given the victim's testimony here today, I just ask that you take that into consideration and place him on pretrial release. Additionally, I would ask for a non-hostile contact order. I don't have his history listed on the sheet, so I don't know if he has any domestic violence history. But I would just argue that given he was the one that called 911, the alleged victim is stating the exact same thing that's listed in the police report. I just ask that you take all of that into consideration.
All right, here's what I'm going to do. Mr. Given, I understand, and I know that you were trying to talk, and I think that your attorney advised you not to. The reason she did that is everything you say in the courtroom is being recorded and can be used against you later. And at this point today, you may want to tell a story, but you don't have to. So I think that's why she was advising you of that. However, I understood from some of your gestures, It sounds like you're saying the same thing that you said in the police report, which is the same thing that the witness is saying here today. Unfortunately, probable cause is a very low standard, and based on what's written here, I still think there is probable cause that you may have committed an assault. But given the threadbare probable cause and the witness testimony, here's what I'm going to do. I'm going to release you on your own recognizance.
Your Honor, just for the record, state would object. He does have a fairly lengthy violent history as well as an out-of-state history that's also lengthy and violent.
What's the lengthy violent history?
He has Florida convictions of controlled substances, trespasses, resistance.
That's not violent. Get me to violent.
He has Florida arrest of assault DV, bat DV, bat DV, ag assault with deadly weapon.
Arrests or convictions?
Those were arrests from Florida. Out-of-state convictions. He has burglaries of an inhabited dwelling ×3.
That's an arrest, right? Not a conviction.
These are convictions from out of state, Your Honor.
Wait, where do you see conviction? Okay, go back, say it again.
Out of state convictions, he has at least 4 burglaries, grand theft of something with violation, illegal possession of stolen things, simple escape, ag escape, and then other out of state arrests, which also include VOPs and an armed robbery, which is a violent offense. I understand that this court
And Your Honor,
will not take it into account. However, he does have violent arrests and multiple arrests and convictions in state and out of state.
Your Honor, he has, he does qualify for pretrial release. I would just ask for pretrial release in this case, if you're not inclined to ROR him.
All right, I'm going to place you on pretrial release. I'll allow peaceful contact with the victim based on the testimony here today, but you're not allowed to drink alcohol, and you're going to be subject to random alcohol screens. Do you understand that? So don't drink anything. Alcohol. Don't drink alcohol. And you can't possess a weapon, firearm, or ammunition. Good luck, sir. Thank you, ma'am. Good luck.
Thank you.
Your Honor, we're gonna try to get Morales up here. He should be coming up.
Okay. Thank you.
He wasn't on our docket.
Okay. Please tell me your name.
Rodolfo Gutierrez.
21MM224. You're here charged with battery. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release in this case?
No, Your Honor. Given his arrest history, state would just ask for bond and PTR. He does have prior DV batteries, bat Leos, assault Leo.
I saw that. All right, I'm going to place you on pretrial release and require that you post a monetary bond, but I'll reduce that to $250. You can't possess a weapon of any kind, firearm or ammunition. You can have no contact with the victim. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. Where did this take place?
At Warner Park.
Do you live there?
Yes.
Okay, hold on one second. I got to pull this up.
Yes, Your Honor, I believe it's alleged that he was knocking loudly, trying to break into the residence of the victim.
So he doesn't live at that residence?
I'm not sure, Your Honor. It just says that he was knocking loudly, trying to break in.
I was living there.
What's your home address?
Where I was staying at now?
Yes.
400 West New England.
Oh, that is what that is. That is that address. All right, I'm going to order that you have to maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. All right, good luck.
We have Mr. Morales.
All right, tell me your name, sir. 21 CF 12826. You're here charged with child abuse. There is probable cause. Look at me, sir. There is probable cause. I'll appoint an attorney to represent you. I'm not sure why this is only one count of child abuse, but it is at this time.
Yes, Your Honor, understood. Arguably the other child, the 12-year-old.
Right. It's a pretty violent episode.
Sorry?
I was talking to the prosecutor, sir. At this time, your bond is $25,000. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
How much, Your Honor? I'm sorry, I missed it.
$25,000. You must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim or the witness, Jessica Flores. Do you understand that?
Can you repeat that last?
You cannot coordinate the visit to collect your belongings with the victim or the witness, Jessica Flores, because you cannot have contact with them.
You didn't have contact with Jessica?
No, she's a witness in this case. No contact. Do you understand?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. You can have no contact with any minor child under the age of 18. Are there any other conditions the state would request?
No, Your Honor.
All right.
Your Honor, did you see anything within the affidavit about DCF?
Oh, sir, I'm also going to order that you have to comply with any plans set in place by DCF.
Say that again?
You'll have to comply with any plans set in place by DCF. All right, good luck. Thank you. They will have contacted them, even if it's not in the affidavit, because of what it is. Please tell me your name.
Wait, no, I just.
21MM6829, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case. Does the state object to pretrial release in this case?
Your Honor, state would just ask for bond with PTR, given the allegation. They punched her in the face with a closed fist. With each strike, he would drive his fist into her mouth, causing more pain and damage. State would just ask for PTR with bond.
Yeah, again, I don't know why this is arrested the way it is.
Yes, Your Honor.
Your Honor, I would just argue it does not appear he has any, he hasn't been convicted of anything since 2005. I'd ask that you take that into consideration.
All right, sir. Your bond is $1,000. You can have no contact with the victim. Do you understand what no contact means?
Yeah, yes, ma'am. Yes.
You can't possess a weapon, firearm, or ammunition. You can't possess or consume any alcoholic beverages. I'll order that you're allowed a one-time return to the La Quinta Inn located at 7931 Detweiler Drive to gather your belongings. But then you can't go back there. Do you understand?
Yes.
All right, any other conditions the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name.
Charles Lincoln.
21MM633, you're here charged with battery domestic violence. Please look at me while you're in the courtroom. There is probable cause. I'll appoint an attorney to represent you in this case. Ma'am, did you wish to testify?
Yes.
Please raise your right hand.
Do you
May I-
solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
My name is Kimberly Lincoln, and I'd like to make a statement, please.
Just a moment. What did you say your name was?
Kimberly Lincoln.
All right. First, I'm going to ask the prosecutor if she has any questions for you, and then you can tell me anything else you want to tell me.
Thank you.
Good morning. Can you please state your relationship to Charles Lincoln?
I'm his wife.
Are you afraid of him?
Not at all.
Do you want to have contact with him while this case is pending?
Absolutely.
Do you believe drugs or alcohol were involved in this incident?
And once I make a statement, I cannot, my husband doesn't drink.
Hold on, I can't hear you.
Sorry?
I know I can't talk through this.
You can take it off. You're in the booth by yourself.
My husband had half a beer. We were at Lake Ridge Winery, and I had a couple glasses of wine without eating something, and I was fighting with his mother. I wasn't even fighting with my husband. He was just trying to get me to stop. And I didn't drink that much, but I didn't have anything in my stomach, and I was fighting over the fact that I am forced to live with my mother-in-law, well, she lives with us. And I just wouldn't stop. He was just trying to get me to stop. I was already against our painting in the hallway. He actually threw his shoe down the hallway just to get me to stop. I wasn't even fighting with him. He didn't hurt me in any way, and I'm so deeply sorry that I called 911. I should have never called. On my 911 statement, I said I do not want police to come. I just want to document what was going on. And if I probably didn't have a couple glasses of wine on an empty stomach and his mom the same, I wouldn't have called. And I'm so sorry to waste your resources and your time. I'm in no way have ever been afraid of my husband. And again, he had half a beer like 6 hours prior. I was fighting with his mother-in-law and for like 30 minutes on the way back from Lake Ridge Winery. And by the time we got home, he was just fed up and he's sick of hearing it. But his mom really doesn't have anywhere to go, and we have a big house. My husband is a prominent businessman and a good husband and beautiful father. I should have never made that call. He just shocked me, and that's all he did. He didn't hurt me at all.
All right. Okay. Thank you.
I'm sorry.
It's okay, sir. Take a minute. Take a breath. Listen, before you say anything, I want to make sure that you understand that everything you say here is being recorded and can be used against you. Do you understand that?
Yes, Your Honor.
Okay. I've appointed an attorney to represent you. Let me give her a moment to speak to you before you say anything.
May I say something else?
Just one moment. Rebecca, why didn't he qualify for pretrial release?
His prints weren't cleared at the time yet, but he qualified.
Okay. All right.
May I say one
Hold
more
on.
thing?
I'm giving them a moment to discuss. And
Yes, Your Honor.
Ms. George,
Yes, Your Honor.
also, just based on what his wife said, I understand we're still under the administrative order that says everyone gets the public defender, but he probably doesn't qualify. So I'm going to ask him about that.
That's fine.
Okay.
He just would like to say one thing to you, Your Honor.
All right, Mr. Lincoln, go ahead. Well, first, let me swear you in. Go ahead.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Thank you.
Your Honor, I'm ashamed and embarrassed and humiliated for the events that happened yesterday. And I love my wife. I love my family. Up to 4 o'clock in the afternoon yesterday, I was living the life of Pleasantville. And thank you, sir. Thank you for your time.
All right, I understand, and I appreciate both of you. Well, I appreciate you coming today. You didn't have a choice, but I appreciate what you're saying. Based on what your wife just said, Mr. Lincoln, do you want to hire an attorney to represent you in this case?
No, I don't want to have an attorney at all, but I can afford an attorney, and I told them that at the, whatever the station that was there.
So here's what's happened. Because of COVID, the Florida State Supreme Court has issued an order saying that everyone gets appointed a public defender, because what they don't want is people sitting in jail unrepresented in the middle of a global pandemic. So that's why I immediately appointed the public defender's office to represent you.
I'll pay her then if I have to, but
But,
I'd rather just,
so there's nothing we can do here today, except the only thing we're doing today is I'm telling you there is probable cause based on the affidavit, and I'm setting your bond. But moving forward, you don't have to have an attorney, but you'd be at a disadvantage if you don't, because the state of Florida is what's prosecuting you right now. It's the state of Florida versus Charles Lincoln.
Understood.
So they have to make a charging decision. I have no idea what they're going to do. They could drop it tomorrow. But I'm not in control of that, and I don't know what they're going to do.
I understand. May I address the no contact order?
I'm not going to order no contact based on the testimony here today. So,
For now, Your Honor, I would just ask that you appoint us, and then once
Okay.
it's an attorney.
Thank you, Your Honor.
all right, I'll do that then. So we'll just leave the,
May I say one more thing?
yes, ma'am.
If I knew that police would come out, although I asked them not to, I would have never called.
So they always do when there's a 911 call?
I didn't know that, I would have
Because
never
they
called.
don't know what they're gonna
I've wasted
find.
all my time. It's he's a beautiful man. I'm so sorry. I was fighting with his mother, not him.
So I understand, but that's not what's in the affidavit. So for now, there is probable cause. I'm not telling you the state's going to file this charge or that they can win at a jury
It needed
trial.
to be quiet, but other than that, that was it.
So I can't change that today.
I'm so sorry.
But here's what I'm going to do. Mr. Lincoln, your bond is going to be $500. I'm going to allow you to have peaceful contact with your wife. Just don't possess a weapon, firearm, or ammunition.
Never had one, Your Honor, and it will be extremely peaceful. You will never hear our names again.
Well, I hope that's right, and I hope that's in a good way.
I can
And
tell you right now, you will never hear my name again.
I can't give you legal advice, but if you're going to hire an attorney, I would do that right away.
Yes.
So that they can start working with the state on your behalf in this case.
Thank you.
All right, good luck. Thank you, ma'am. Good luck.
Thank you for letting me talk so much.
Yes, ma'am.
Thank you.
Put your mask back on.
Oh, sorry.
You know, I hate to use the resources of the public defender's office if we know they can afford an attorney. But we still have that admin order, so. Please tell me your name.
Tiffany.
21MM225, you're here charged with battery. There's probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with a victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. You must comply with any plan set in place by DCF. Was the child present? Miss May, do you remember that?
Can I ask a question?
Yes, ma'am. Everything you say is being recorded and can be used against you later. Do you understand?
Yeah.
Okay.
When the incident happened
Don't talk
last night, they said that they had it on video, and if the police actually looked at the video and seen that it was not me, nor was it the right day and time, we would not be here. And also, I was trying to get away from the house. I was trying to
Don't talk
get
about,
into my car.
don't talk about the facts of the case.
But my kids were not present at the time at all, because this happened outside and the kids were inside the house.
Your Honor, I don't see it within the affidavit.
Because it says DCF.
It says DCF was contacted, but I don't see mention of the children within the affidavit.
All right.
The officers may have just not written it.
Because the children were there.
I'm
All right.
not sure.
All right. Good luck, ma'am. Yeah, because it's in there. So I don't know if they're going to do something or not. Please tell me your name.
Nolan McDougall.
21MM6826. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release?
No, Your Honor. However, Your Honor, they are from Ohio, I believe.
All right, so I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You can't possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. You can't have contact with any witness in this case either. All right, good luck.
Your Honor, are you ordering a separate residences?
Oh, yeah, you have to maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. But you can't live together. You understand that? All right, good luck.
And you stated he could return to Ohio, correct, Your Honor? Oh,
I don't care if he goes to Ohio.
Okay.
I don't ever say that.
okay.
No. No one has shown me any law that says I have to say that.
I think it's PTR they struggle with.
We're not requiring you to say that anymore, Your Honor.
Yeah.
Okay, I didn't know, I just, sorry.
Because it's just about him coming back for court, as long as he comes back.
Okay.
Please tell me your name.
Patrick Nicholas.
21MM6828. You're here charged with battery, domestic violence. There is probable cause, and I'll appoint an attorney to represent you.
He could qualify, Your Honor.
I'm going to place you on pretrial release with special condition and require that you post a monetary bond, but I'll reduce that. Hold on a second. All right, I'm just going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir. Please tell me your name.
Jonathan Ocampo.
21MM6812. You're here charged with battery, domestic violence. There is probable cause, and I'll appoint an attorney to represent you. Ma'am, do you wish to testify?
Yes.
Please raise your right hand. Sir, you look at me. Sir,
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, thank you.
Please state your name for the record.
Allison Ocampo.
go ahead, Ms. May. Mr. Ocampo,
Yes.
you look at me or at this wall. You don't look at her.
Okay.
Okay. Go ahead, Ms. May.
Good morning, Ms. Ocampo. How do you know Jonathan Ocampo?
He's my husband.
Are you afraid of him?
No,
Do you want to have contact with him while this case is pending?
no.
Has anything like this ever happened before?
Yes,
Approximately how long ago would you say the last time was?
a week ago.
All right. And do you believe drugs or alcohol were involved in this incident?
Yes, alcohol.
And would you feel comfortable calling 911 if anything like this or anything more severe ever occurred in the future?
Yes.
All right, thank you. That's all I have.
Thank you. Ms. George?
No questions, Your Honor.
All right, thank you, ma'am.
He does qualify for pretrial release, Your Honor. I would ask for pretrial release. It's showing his last conviction was in 2007. No failures to appear.
All right, sir, I'm going to place you on pretrial release and require that you post a monetary bond, but I'll reduce that to $250. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes.
All right, good luck. Thank you, ma'am. Good luck. Please tell me your name.
Wingley Saintville.
21 MM 6832. You're here charged with violation of a condition of pretrial release on a domestic violence case. There is probable cause, and I'll appoint an attorney to represent you.
Yes.
Sir, everything you say is being recorded and can be used against you later. Do you understand that?
Yes. No, I thought I had a public defender for this case already, but I found out that the case had dropped down to a misdemeanor. And I didn't find that out when I went to my initial court date, and the court date had changed. Me and my girl were on the assumption that the no contact with order was done after 30 days. And that's what we communicated on. She said she spoke with the attorney's office about that. She's trying to drop the charges. There was no violence in this predicament. We just were unaware that.
Stop talking about the facts of the case.
Okay. Well, we're just not sure if there's no kind of.
So here's the thing, sir. If a court orders you to have no contact, you can't change that. Your girlfriend can't change that. The attorney can't change that. Only another judge can change that order.
Yeah.
So.
I didn't know that. It was 30 days went by, and I just had no idea. And I went back. We went
Stop
back.
talking about the facts.
There's no 30 days.
Okay.
There's no end on this. At this time, you can have no contact with her. Do you understand what no contact means?
Yes, ma'am. I completely understand that.
All right, your bond in this case is $15,000. No contact with the victim. You cannot return to that residence for any reason. You can't be within 500 feet of her residence or place of employment. Do you understand that?
Yes, I completely understand that.
You cannot possess a weapon of any kind, firearm, or ammunition.
I completely understand that.
And at this time, I'm revoking your bond in 21 MM 6168.
Your Honor, I would ask that you not revoke the out on bond at least. Your Honor, if you look at the arrest affidavit, the victim also confirms the exact same statement my client just stated in court. I believe that now that you set the bond high, you set the bond at $15,000, I think that's sufficient enough to keep him from violating the court's order. So I just ask that since it's out of the same incident that you take no action, there was no additional violence, and the girlfriend does confirm the statement made today to you, Your Honor.
I just honestly don't want to lose my job today on it. I've been working really hard, and
Where do you work?
I work at Dollar Tree on Central Florida Parkway near SeaWorld, and my unemployment has been cut off for 3 months since the hack happened. So I've been working every day, and I've been paying the bills, and it's just going to bring us all the way back down.
Not us right now, sir, because you can't have contact with her.
No, I can't. I won't have contact with her, but I can move on. I just need to go to work and pay my car note and pay whatever I need to pay and just keep going. There's nothing.
Who's the victim of the battery that was downgraded from a felony?
It's the same victim, Your Honor. And state's only concern is in the original affidavit, even though the victim was under the impression that he could still live at the residence due to him having established residency there, when she was informed otherwise that was incorrect, she said that she wanted him to leave.
She stated what?
That she wanted him to leave and gave law enforcement the keys to the door to get him to leave the house. So it seems like the victim still would prefer that a no contact be in place.
I think, is that my attorney right there?
Again, Your Honor, I'm just pointing to the fact that it's nonviolent. He's not committing another battery. There's a misunderstanding. would just ask that you not hold him at no bond on the battery. My client just stated that he's currently trying to work due to his unemployment being cut off, and
I am currently working right now.
so I think that you setting the bond at the 15,000 is sufficient to prevent him from going back over there, Your Honor.
So another purpose of the no contact, in addition to keeping the victim safe, it's also so the defendant can't tamper with a witness in a case. It's an ongoing criminal case. He's been arguably tampering with the witness this entire time. So I'm not inclined to release him on that.
And okay, could you just stop? Your Honor, again, I would just point to the fact that he was forthcoming with you. He stated what he thought. It is confirmed in the arrest affidavit. It's nonviolent. I just ask that you consider that before holding him in here at no bond.
A condition of being out on bond is that you not violate any new laws. You can't be arrested for committing a new crime if you're out on bond for having committed a crime.
I 100% completely understand that, and I stayed away from any crime doing anything. This right here wasn't violent at all. She found out about the no contact, contacted them, but we were both living. She made me come home. I worked. We lived an honest life. It was just nothing happened. Like, if I was to get out.
This is what happened, sir. This is a crime.
I know, and I understand that. I understand that.
Let me ask, what says the state?
Your Honor, I'll leave it within your discretion. My only concern was it did seem like she wanted him out of the apartment, and he was out on bond and signed a no contact order, and is imputed to have understood it, given that he signed it and has a copy of it. But I'll leave it within your discretion.
Do you have the affidavit for the battery case?
Yes, Your Honor, 1 second. I can print it for you.
I honestly thought we might be done with both sessions by this time. We're not even done with one.
Thank you.
Thank you. So why did the state file it as a misdemeanor?
I have no notes from that ASA. Since I don't have the file, it's potentially written in the file. I'm not sure.
Does the state not file something in the court file when you do that, when you remand it from felony? You know, like I don't think the state does that, but on an announcement of no information, you say why you're not filing the case. When you guys remand it, when you file the charge, we don't file anything like that?
No, Your Honor. And usually that would be something that would be put in like the ASA notes. And I don't see anything in here or within the synopsis within our case management system. And I don't see anything.
Mm-mm.
I think it might be the deadly weapon. Came in with the deadly weapon. And there was an allegation regarding a chair.
Mm-hmm.
So I think the ASA decided that they weren't going to go for it on the deadly weapon due to the chair. Potentially, I'm not sure. I don't have notes from the ASA, but that is a potential reason.
My notes are stating that there may be a witness problem, Your Honor.
Arguably exacerbated by your client living with the witness.
No, the roommate, I guess there was someone else,
Yeah.
not hers.
I'm not doing it. You have no bond on the battery case, so your attorney's gonna have to file a motion in front of the trial judge. Good luck, sir.
It was nothing violent about this.
I know, I'm not gonna change it. You'll have to file a motion. Good luck. I don't know if you want that. It doesn't go with this case, it's the Audubon, oh, sorry. That's from the Audubon. But because she gave it to me. No, I don't need it. Please tell me your name.
Calvin Thomas.
21 6819, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Let me look this up really quickly. Your bond is $1,000. You can have no contact with the victim. Do you understand what no contact means? Hold on, wait a minute. Is his only conviction the robbery from 2015?
Yes.
All right, I'm going to reduce that. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. You understand?
Okay.
All right, good luck, sir. Please tell me your name. 21 6822. You're here charged with battery dating violence. There is probable cause. I'll appoint an attorney to represent you. When was this last domestic battery, Miss May? Do you know? And why? What did the state do with it? It says it's the same victim.
Yes, Your Honor, it was a 21 misdemeanor bad TV. It was Mr. Figueroa. The victim declined to prosecute. That arrest was in June and closed in July.
Does the state object to pretrial release?
Your Honor, given the prior history, state would ask for PCR with a bond.
All right, I'm going to place you on pretrial release and require that you post a monetary bond, but I'll reduce that amount to $100 with special conditions. You can have no contact with the victim. Do you understand what no contact means? Yes. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I will allow a one-time return with law enforcement to gather your belongings. Good luck, ma'am. Please tell me your name.
German Ramos.
Just a moment. It looks like you have a warrant out of Osceola County in 21 MM 2327 for a domestic battery I don't understand how we're supposed to set bond on a DV case when he was arrested on a warrant. Was the victim notified to be here?
I'm unsure, Your Honor.
Because the victim has a right to be at the hearing. How would they be notified on a warrant? Oh. There's a note on the affidavit that says the victim notification card not submitted by arresting officer. Rebecca, can you tell me if you guys were able to get the victim?
No, we weren't able to make contact.
I think we have to reset this for tomorrow. The victim has a constitutional right to be at the hearing.
Judge,
Yes, sir.
can I say something?
You can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
Yes.
Okay.
Okay, so we got the Jessica complained on that day, you know, and after that day, she called my sister, but she doesn't call 911, you know?
Don't talk about the fact.
So I'm going to give you a moment to talk to the public defender. I'm going to appoint the public defender's office.
Your Honor, did they leave a voicemail for her?
We didn't have any information to.
No information.
There's nothing.
The thing,
I don't even.
The thing is that I go back to that location 4 times after the accident, you know, and nothing happened, and then.
Don't talk.
I'm just going to give you a moment to talk to Ms. George before you say anything else on the record. Also, I don't understand this in the warrant. It says, bond none to be set at IA. So is it none or is it to be set at IA?
We
always come in.
Yeah, we dealt with this like last week too, I believe.
Right. The warrant shouldn't say that. Does he have any other charges?
No, Your Honor, just this.
I don't, tell me if you guys think I'm wrong, but I think a DV victim has a constitutional right to be at the hearing.
You're correct, Your Honor. He does have, looks like at least some prior arrests. And looks like a few prior convictions.
I really can't hear you, Miss May.
I don't, when you asked if he has anything else, were you asking if he's seen on anything else or?
Yeah, no, is there anything else holding him or is it just this one case, this one warrant?
Oh, I believe it's just that.
All right, so I'll hear from both of you. I don't know what to do with this.
I'm trying to look at the.
I don't know if anyone has the information to call the victim.
That's what I'm trying to look at the.
At which point would he just sit here?
For 24 hours. Because if they.
No, I'm saying if there's no information on the victim, he sits here for 24 hours, he comes back, there's still no information on the victim.
Well, I think if they make a good faith effort to find it, like they'll have to research and see if they can find it.
I have her name, address, and DL number. I can ask an investigator to get me a number.
Then if they don't, I agree. We don't keep him here for 30 days till they can find the victim. But because she has a constitutional right to be at the hearing, I don't think I can do it knowing that no one made any effort to get in touch with her.
No, I understand, Your Honor.
Okay. All right, so we're going to continue this for tomorrow. So you'll be seen by the judge tomorrow. Unless, if you get, we have to come back at 1 for the other case. So if you happen to get in touch with her before 1 o'clock, then you just bring him back today. But I'm not holding my breath for that either, so. Did the state talk to her? That's why I asked her to stay, it was for them, so I don't need her to stay.
I was gonna, once we finish, I was gonna ask if we could.
Okay. So she has to wait for the state.
I mean, she can go.
She what?
I mean, are we talking about the witness that is waiting? Yeah, no, I don't need her.
She doesn't have to come back. That's up to her. If she wants to, she can, but she does not have to. That's this whole thing. They have a constitutional right to be here, but if she doesn't want to, she doesn't have to. We just can't deny them that right.
Thank you.
All right, so we'll see you tomorrow, Mr. Ramos.
Thank you very much.
Good luck. Victim contact? Victim notification, that's it. All right, sir, please tell me your name. Wait, hold on 1 second, I'm in the wrong place on my computer. Mr. Pryor, is that what you said? All right, give me 1 second, sir. All right, Mr. Pryor, you're here for two things. It looks like 20 CF 10737, it's a violation of probation. Let me pull up that warrant and I can tell you what the allegation is. The allegation is that you failed to report as directed. You changed your residence without first procuring the consent of your probation officer. And there's no bond authorized on that warrant. I'm going to appoint an attorney to represent you in that case, sir. Then you have another case, 21 MM 632, where you're charged with resisting an officer without violence. There is probable cause for that arrest. I'll appoint an attorney to represent you in that case as well. Your bond on that is $500. And you can't return to the Lynx bus stop at Silver Star Road and Dardanelle Road. Do you know where that is? Yes. All right, good luck, sir. So do I give you this? Okay. Then we have 33 days. Is the state ready for those?
Yes, Your Honor. Nicholas Donato, 21 CF 1152.
We're waiting on the defendant.
Thank you, Your Honor.
Sir, please tell me your name.
I'm sorry, Your Honor. Are we using the headsets, Your Honor?
No, overhead, because I have a witness here as well.
Thank you, Your Honor. And for the record, this is Rafael Barrera, State Certified Court Interpreter. Señor, por favor, dígame su nombre.
José Manuel Ordóñez.
Okay, despacito, señor, en voz alta, habla el micrófono. Your Honor, I'm just instructing him to speak slower and speak louder so the interpreter can hear.
Thank you.
José Manuel Ordóñez Argueta.
José Manuel Ordóñez Orgueta.
Sí.
Yes.
All right, this is 21 MM 6816. We are continuing this hearing from this morning. Ms. May, what says the state?
Este es el caso 21MM 6816. Estamos continuando la vista de por la mañana. Licenciada, ¿qué dice usted?
Your Honor, I did speak to the head of our DV division, and she wants us just to go forward on what is currently charged, the BAT DV. Given that
Eso, señoría, hemos hablado con la encargada de la División de Violencia Doméstica. Quiere que procedamos con el cargo que tenemos, que es la agresión de violencia doméstica.
she did, however, advise that she herself will be filing charges within the week and anticipate that they will be felonies.
Pero ella me acaba de indicar que ella va a radicar cargos antes de que termine esta semana, que serán cargos de delito mayor.
Given the victim's testimony from earlier, state asked that you not put him on PTR, given the facts in the case that we've already argued earlier.
Y basado en el testimonio de la víctima, le pedimos que no lo coloque en libertad provisional, basado en los hechos que habíamos hablado anteriormente.
Also, state asked that you do no contact with the victim, also due to her earlier testimony.
Y también la Fiscalía pide que emita una orden de no contacto con la víctima, también basado en el testimonio de la víctima.
All right, thank you. Ms. George, did you have any further argument?
Muchas gracias, licenciada George. ¿Tiene usted argumento adicional?
Your Honor, he does qualify for pretrial release. I would ask for pretrial release. If you're not inclined to place him on pretrial release and a monetary bond, if they're going to file the additional charges, he's going to have to pay the bonds on those charges.
Él sí reúne requisitos, su señoría, para libertad provisional. Si prefiere no la libertad provisional, entonces libertad provisional con fianza. De todos modos, si ellos van a entablar cargos en contra de él, él tendrá que pagar la fianza en esos cargos adicionales.
All right, sir, at this time, I'm going to place you on pretrial release and require that you post a monetary bond.
En este momento, caballero, lo voy a colocar a usted en libertad prejudicial y voy a exigir que pague una fianza monetaria.
Your monetary bond in this case is $2,500.
Su fianza será programada en $2,500.
You are not allowed to have any contact with the victim. Do you understand what no contact means?
No se le permitirá, se le va a prohibir contacto con la víctima. Usted sabe lo que eso significa. Yes.
You cannot call her. You cannot text her. You cannot send a message through friends or family. You cannot go to her house. You cannot contact her on social media.
Usted no la puede llamar, no le puede enviar mensajes de texto, no le puede enviar recados mediante una tercera persona, no puede dirigirse a la casa de ella, no puede tener contacto con ella en absoluto.
You cannot possess a weapon of any kind, firearm or ammunition.
No puede portar armas de fuego, municiones o armas blancas.
You cannot possess or consume any alcoholic beverages or any controlled substance without a valid prescription, and you'll be subject to random drug and alcohol screens.
No puede ingerir alcohol o ninguna sustancia ilícita o sustancia controlada que no sea que tenga receta, y tendrá usted exámenes de drogas al azar a su costo.
You cannot return to the victim's residence for any reason or be within 500 feet of her residence or place of employment.
No puede regresar a la residencia, no se puede acercar a menos de 500 pies de su residencia o de su lugar de empleo.
Any other conditions the state would request?
¿Fiscalía está pidiendo algunas condiciones adicionales?
No, Your Honor.
No, su señoría.
Good luck, sir. Thank you, ma'am, for coming. Good luck.
Buena suerte, señor.
Mr. Interpreter, if you don't mind telling this to the victim, I'm handing her a card that has the state attorney's phone number on it. She can give them a call, but they will be otherwise in contact with her shortly.
Si por favor puede llamar a las oficinas de la Fiscalía en este número que le está entregando la tarjeta. De otros modos, ellos la contactarán a usted en corto plazo.
All right, any other Spanish cases this afternoon? All right, that's all we need from the interpreter. Thank you.
Thank you, Your Honor. Have a nice afternoon.
Yo tengo una.
Wait, I think she has a question. Oh,
He disconnected.
yep. Do you have a, hold on.
Quiero pedirle al-
I'm sorry.
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter, already previously sworn.
All right, thank you. I disconnected too quickly. I believe my witness has a question and needs the services of an interpreter. Can you ask her if she has a question for me, please?
¿Acaso tiene usted alguna pregunta que hacer?
Sí, yo quería pedirle a la jueza que lo obligue a pagar todos los daños materiales que él ha causado.
Yes, I would like to ask Your Honor to make him pay for all the damages, material damages that he has caused.
I'm sorry, ma'am. At this time, I can't do that.
Me disculpo, señora, porque en este momento dado no se me permite hacer eso.
But when you call the phone number on the card that the state attorney is going to hand you, tell them that.
Pero cuando usted marque el número de la tarjeta que le va a entregar a usted el fiscal, eso se lo puede notificar a ellos.
You understand?
Okay. ¿Entendido?
Sí.
Yes.
All right, thank you. And for the interpreter, this is 21 MM 6816. The defendant is Jose Ordono Argueta.
Thank you, Your Honor. Do you still need the interpreter to stay connected for another
No.
case, or may she just, okay.
That's all, thank you. So it's 500 feet for both. Okay. Please tell me your name.
Anthony Richard Burnett.
This is 21 6830. Sir, you're here charged with resisting an officer without violence and trespass on property after warning. Was there an offer?
Your Honor, there was an offer from the state. A withhold of adjudication credit time served and no return. However, my client would qualify for, likely qualify for pretrial diversion. He has no record. We would just ask, because he was going to accept the state's offer here today, because he can't afford to post the bond, and due to the fact that he's homeless, he doesn't qualify for pretrial release. I would just ask that you ROR him. If he, I was going to ask if he stays in contact with his attorney until he gets stable housing, because he was going to go back to one of the homeless shelters, but he's not allowed to get mail there. So if he stays in contact with his attorney, checks in one time a week until he's able to find that stable housing, would you allow him to be ROR'd on this case, Your Honor?
All right, there is probable cause here, sir. What says the state?
Your Honor, state has no objection. I believe the facts in the case, it did seem like he was trying to obtain more medical treatment, even though the hospital did not deem it necessary. And given that he has no criminal history, state has no objection to ROR.
All right, sir, I'm going to release you on your own recognizance. I'm going to appoint an attorney to represent you, but you must maintain contact with your attorney, and you can't go back to Advent Health, Orlando, without a doctor's appointment or unless it's an emergency. You understand?
Yes, I
All right, so if there's an emergency, you can go to the hospital, but if you don't have that or a doctor's appointment, don't go back there. All right, good luck, sir.
Yana Cabrera, behavior.
All right, that's 21 6831. I'm going to appoint the public defender's office. It's a trespass. Did you want to?
Reset for tomorrow, Your Honor. I believe on, is he medical?
Behavior.
Oh, yeah, can we reset? Because I believe there was also, they were going to resolve that out on bond as well.
All right, we'll reset that one for tomorrow. Do you want to do the arraignments? Yeah, just before we bring those in. Does one of you have the arraignments? Do you guys have them?
Yes.
Can you call them?
Oh, yeah. Do you want?
Yes.
Marcus Demps, 21MO988.
We're appointed, well.
You are?
Sorry.
Are these all medical?
Yeah. Are you ready? Okay.
Go ahead.
I'll waive the appearance, Your Honor, and enter a plea of not guilty.
Division 82, pretrial conference, October 25th at 10:30, courtroom 10B.
James Ford, 21MO1050.
You're appointed, Ms. George.
I'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 81, pretrial conference, October 21st at 9 o'clock, courtroom 4E.
Chisia Hall, 21MO1023.
I'll waive the appearance and enter a plea of not guilty, Your Honor.
And they're all medical? Ma'am? No. Okay. Division 80, pretrial conference, October 21st at 9 o'clock, courtroom 9C.
So what's that one?
She was medical.
Okay, she was medical. All right.
Ford refused. Demps was medical, and Bell was medical.
All right, go ahead to the next one then.
Eric Holcomb, 21MO1025.
I'll waive the appearance and enter a plea of not guilty. Why
Just waiting
was
for them to do it.
restricted?
So medical.
Yes.
Division 85, pretrial conference, October 11th at 9 o'clock, courtroom 4A.
Kenneth Lyman, 21 MM 5993.
Nope, I don't have that person.
I entered.
Madam Clerk, Sydney.
Was it a earlier?
Mhm, yeah.
So he was waived.
Yep, I waived that one earlier.
Justin Myers, 21 MM 5844.
I'll waive and enter plea of not guilty. Restricted. Medical, sorry.
Yes.
Division 62, pretrial conference, October 18th at 9 o'clock, courtroom 9B.
Rodney Saintville, 21 MM 380.
Nope.
Waived.
The only other one I have is Bell. Ada Bell,
Refused.
21 MM 5921, refused court.
I will enter plea of not guilty, Your Honor.
Division 63, pretrial conference, October 28th at 1 o'clock, courtroom 12C.
Thank you, trying to save my voice. Please tell me your name.
Will Flores. God bless you.
Good afternoon, sir. 21 MO 1112. I don't think that's right.
Flores?
Hold on, I'm really confused. I have. Oh, that's the MO case of disorderly conduct, and then the MM is 21 MM 6821.
Yes, Your Honor, there were offers conveyed on both. No information as to the paraphernalia and a withhold credit time served as to the disorderly.
And I did speak to Mr. Flores. We went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer here today.
Go ahead and raise your right hand, sir.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
So help me God.
All right, sir, you had a chance to speak with an attorney about the rights you'd be giving up if you enter a plea to these charges. Do you understand those rights? Do you have any questions for me about them? Mr. Flores, did I see you back in July? Do you recognize me? Were you here for a disorderly conduct?
In July.
Yeah, it looks like your last conviction was in July for disorderly conduct. You look familiar to me. All right, sir. You understand that if you're on probation anywhere, this plea can violate that probation. You understand if you're not a U.S. citizen, you can be deported. Sir, did you have a chance to review that form in front of you that further explains the rights you're giving up?
Yes, ma'am.
Do you have any questions for me about those rights?
Ma'am.
All right, at this time, how do you wish to plead to disorderly conduct?
No contest.
You can plead
No contest.
no contest, guilty, or not guilty.
Contest.
No contest? And you understand if you enter that plea, you'll be giving up all those rights, and I will sentence you today.
Yes, ma'am.
All right, I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the time that you've been in jail, which is 2 days. Thank you. I have to order that you pay court costs, sir. I'll give you a year to pay those.
And state has an announcement as to 21 MM 6821, the possession of drug paraphernalia. State announces that no information.
All right, good luck, sir. You have 30 days to appeal in writing.
Thank you. I'm homeless.
I'm sorry? I can't hear you. Get close to the microphone.
I'm homeless.
Okay.
So
You don't have to appeal. I'm saying if you wanted to appeal, you could, but you'll be released today. All right. Good luck, sir. I don't know, you wouldn't want to appeal that, but.
Yeah.
Please tell me your name.
Jennifer Lamar.
21 MM 6823. You're here charged with possession of drug paraphernalia. There is probable cause.
Your Honor, state's going to announce a no information.
All right, ma'am. The state has dropped the charge against you. Does she have any others?
No, Your Honor.
No, ma'am.
All right. Have a nice day, ma'am. You'll be released today.
Nadine McCall was refusal.
All right. 21MM6825. I'm going to appoint the Public Defender's Office.
I'll waive, Your Honor. However, I just would ask that you take no action on the out on bond. There is competency issues and concerns, and I believe she actually was supposed to have a competency hearing today, from what I saw in the notes.
My understanding is the PD's filed a notice of incompetence on 9/2. Dr. Arias was in the process of evaluating, however, that evaluation had not been provided yet. So there's been no findings of incompetence to date.
Your Honor, may we approach, please?
Yes.
in this case?
Hold on. All right, so what I'm going to do is I'll set that bond at $500 with a no return. I'm going to take no action on the out on bond case at this time. That was
McCall.
maybe.
Your Honor, Mr. Parnell, his behavior.
21MM634, Ms. George. It's a trespass.
Can we try for tomorrow, Your Honor?
We can. We'll reset him for tomorrow. Sir, please tell me your name.
Richard Nowacki.
21MO778. A capias was issued for your arrest for failing to appear for a court date on a charge of indecent conduct. The public defender has already been appointed to represent you in this case. Your bond is $200. Good luck, sir. Sir, please tell me your name.
Nelson Figueroa Ivan.
Was there an offer in this case?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
Ms. George, did you have an opportunity to speak with him about that?
Oh, sorry, I did, Your Honor. We went over all the rights we would be giving up. He understands those rights and he would like to accept the state's offer here today.
Please raise your right hand, sir.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God? Yes, ma'am. Thank you.
All right, Mr. Figueroa, there is probable cause for this charge here today. You had an opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No.
Sir, did you have an opportunity to review that plea form in front of you? It further explains those rights.
Yeah, I know them already.
All right, you have any questions about that?
No.
Sir, you understand if you're on probation anywhere, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a U.S. citizen, you can be deported?
Yes, ma'am.
All right, understanding all of that, how do you wish to plead to the charge of camping where prohibited?
No contact.
All right, sir, I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'm going to reduce that to a lien. Good luck, sir. You have 30 days to appeal in writing.
All right, thank you.
Also, Ms. George, if you can remind me when it's charges like that or if they're obviously homeless, because I think the guy earlier just this afternoon, I don't think I reduced his to a lien, but I think he was in a similar situation.
Okay.
So it is my intention when it's that obvious to reduce that to a lien.
Okay.
Do you know which one it was? No. Then no. Please tell me your name.
Yarrow Henson.
21 MO 1114. You're here charged with disorderly conduct. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
And Mr. Pinto would like to accept the state's offer. And he understands all the rights he would be giving up here today, Your Honor.
All right, just one moment. There is probable cause here. Sir, please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Thank you.
All right, you had a chance to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights?
Your Honor.
Do you have any questions for me about them?
Oh, Your Honor.
Did you have a chance to review that form in front of you that further explains those rights?
Yes, Your Honor.
All right. Take a look at that, sign the bottom, let me know if you have any questions.
He already signed it, Your Honor.
Oh, we did?
Yes.
Okay. All right, sir. You understand if you're on probation anywhere, this plea could violate that?
Yes.
If you're not a U.S. citizen, you could be deported?
Yeah, I understand.
All right. At this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. Sir, do you have a job?
Not at the moment.
Do you have a place to live?
I have relatives that I can stay at, yes.
All right, I'm going to reduce that to a lien as well. Good luck, sir. You have 30 days to appeal in writing.
Okay.
Been interesting. I kept in the day for that, right? Please tell me your name. Good afternoon, sir. You're here charged with disorderly conduct in 21 MO 1115. Let me ask the state if there's an offer.
There's not, Your Honor.
There's not? All right.
Basis of the disorderly was a battery. He's not on bond for a battery that occurred 2 months ago.
I do see that. Reviewing the affidavit, there is probable cause here. Your bond is $250. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
Your Honor, I would just ask that if you are inclined to revoke, you revoke and double the bond. He has 0 failures to appear. And it looks like other than that battery, his last conviction was in 2013.
Thank you. You can't possess a weapon, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription. Do you live at 219 South Paramore Avenue? All right, then I'm not going to order you not to return there. However, because you were out on bond for a battery and committed another battery, at this time, I'm going to revoke your bond in 21 MM 4898. So your attorney is going to have to file a motion in front of that trial judge.
So I thought this,
It's a disorderly conduct.
it's not a criminal charge, right?
It's what?
This is a criminal charge.
Yes, sir. It is. And the basis of it is a battery, an alleged battery. So because of that, because it's a violent offense and you were out on bond for a violent offense, I am revoking that bond. But your attorney can file a motion in front of the trial judge to get you a new bond. Good luck, sir. Please tell me your name.
I was Ramon Nunez Ayala.
One moment. #21 CT 6505. You're here charged with driving while license suspended. Second or subsequent offense. There is probable cause.
Your Honor, I did convey an offer of a withhold credit time served. I did pull CCIS and I couldn't find a prior Dwellis. However, I do believe he would be a good candidate for PTD.
And because of that, Your Honor, we would just ask that you stay the bond. I think it's 1,000.
I'll stay the bond at $1,000. Sir, you can't drive without a valid license. Do you understand that?
Yes, ma'am.
He has a holdout of Lake County. Is that true?
It's for a failure to appear for a driving while license suspended for $2,000.
Does he have a bond? No.
$2,000.
Oh.
All right, so you have a warrant for failing to appear out of Lake County, so you'll be held on that, although I think there is a bond. But I just want to make you aware that you have that hold as well. So you'll have to post bond in both cases to give out. All right, good luck. Please tell me your name.
Landon Barnes.
21 CT 6506. You're here charged with no valid driver's license. Give me one moment. 21 CF 12822. You're here charged with grand theft of a motor vehicle. In both of these cases, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $1,500 on the CF case. You can have no contact with any victim or witness. And the no valid driver's license, your bond is $500. Sir, you can't drive without a valid Florida license. Do you understand?
Yes, ma'am.
It shows that he's on probation and is a violent felony offender of special concern. So I don't know if that's right, but
He has a hold.
he does have a hold? Okay. So you have a hold for those things as well. Good luck, sir. a moment, sir.
Good afternoon, ma'am.
Good afternoon. Please tell me your name.
James Leslie Coney Jr.
You're here in 21 CF 12812, charged with possession of cocaine and drug paraphernalia. I'm going to appoint an attorney to represent you in this case. Give me one moment.
Your Honor, I would argue no PC only because all of the drugs were found on the passenger. The passenger had the drugs on their mouth. The passenger had the drugs on their lap. All of the drugs were found on the passenger seat. Nothing was found on my client.
Your Honor, the defendant told law enforcement that it was his vehicle, and when asked the question of would it be reasonable to know everything that's in your vehicle, he did answer yes. I believe the cocaine that is being associated to Mr. Coney is that was on, I believe it was on the gear shift, which would be directly between the driver and the passenger, which in this case, Mr. Coney was the driver.
And I would just argue that it was in the middle by the gear shift. It was in a container. However, Your Honor, I would argue that the drugs were in a closed, I don't know if it was like a bottle, and the officer didn't know until he opened it. So I would just argue that there's no way for my client to know that there were drugs in there.
Your Honor, under constructive possession, he's known to have dominion and control over any items that are within his immediate reach. The gear shift, even if it's in a container, is within his immediate reach, and he's imputed to have dominion and control over said items.
I would argue that he has to know what's in the items, Your Honor. Even if, the court stated, even if he is well, they call it constructive possession, but if it's near him or around him, he has to know that it's there. In one case, they pointed to the fact that it was in plain view, so that's why I would argue that it's inside of a container. There's no way to know that he knew there were drugs in that container. If you notice in the arrest affidavit, the passenger threw paraphernalia out of the car. All the drugs were located on the passenger. It's easy for the passenger to, when the officer told him to get out, to leave the rest of his drugs inside the vehicle near the gear shift.
So I understand constructive possession. I also understand there can be joint possession of an item. But, hold on one second. Where I'm struggling, Ms. May, is isn't possession still, he has to have knowledge, or is it knew or should have known?
Newer.
Point me to that in the affidavit for Coney, not Watkins.
I mean, I'd point to, one, the officer asking him, well, the officer asked him about the chapstick container. He never said he doesn't even know what he's talking about. He said that it wasn't his. The officer also asked him if the vehicle was driving was his. He said that it was registered to him. And the officer asked, would it be reasonable to know, or should you know what everything that's in the vehicle? The defendant did agree. Then they went on to have a conversation regarding, it seemed to change several times between his relationship with the defendant, Mr. Watkins. But under constructive possession or even joint possession, it's knew or should have known. And given that he had dominion and control of the vehicle and it was his vehicle and it was registered to him, he's imputed to have that knowledge to know what was within his vehicle.
And again, I would argue that all the items were found on the passenger, Your Honor. Again, the drugs were located in a chapstick bottle. There's no indication in this arrest affidavit that he knew what was in that chapstick bottle. He got out the car, and then they told the passenger to get out of the car. It's easy to think that he left the remaining drugs and items that he was trying to get rid of before he exited the vehicle. So I would just argue that based on the four corners of the arrest affidavit and the fact that even in the beginning of the arrest affidavit, the officer asked him for his driver's license. My client was upfront with him about everything. He didn't have his driver's license on him. He gave his veteran's ID. And then he, in turn, the officer did check to make sure he had a driver's license and found out he was, in fact, telling the truth. I would just argue that there's still no PC for constructive possession based on the know or should have known.
All right, Ms. May, I need you to help me out. How could he know or should have known that a closed, opaque container contained an illicit substance?
Because it's within his vehicle that he has dominion and control over. You're imputed to have knowledge of what's in your vehicle. We have PC all the time for someone that has drugs in a trunk in a vehicle, and they're imputed to have knowledge that those drugs are there, even though they can't actively see them at that time. If you're in active possession and control of that vehicle, you're imputed to know everything that's in it, including any unlawful activity that's going on within it.
And Your Honor, I would argue against that. Case law stated that even for constructive possession, the reason that they found PC in this case was the fact that you could actually see the drugs in the vehicle and it was marijuana. And the court determined that there was PC for constructive possession. But without that knowledge or intent, without proof of that, you cannot have constructive possession.
So I get the constructive. I also get imputed knowledge based on he owns the car, it's in his car. But because we have the passenger with all the drugs on him, throwing it out the window.
Wouldn't he be imputed to have knowledge if he sees drugs all over the defendant as well, or the other co-defendant? It's on his face, it's on his chair. If he's in a car with this other co-defendant with drugs on his face, drugs on his chair, and he's throwing things out the window twice, wouldn't that also impute knowledge that something is not right?
Well, at this time, I would argue he's pulling over. The officer gets over the loudspeaker, he's pulling over. When he's getting ready to stop, he tosses the paraphernalia out of the window. And
twice.
Yes, but at this point, the police officer's pulling him over and he's trying to get rid of the drugs. So if I'm already driving and I'm pulling over and someone starts trying to get rid of all their evidence, yeah, at that point, I would know because I see him all of a sudden after being pulled over, he's throwing everything out. But that doesn't mean that I knew once he got in my car that he had drugs on him.
If we're gonna speculate, then we could have also speculated that the defendant wanted to get rid of all the drugs he had. He would have also got rid of that chapstick tube if that also was his. Since he was getting rid of everything else on his person, if that was the other co-defendant's, maybe he would have got rid of the chapstick tube as well. Since he was getting rid of everything else that was on his person.
Okay, let me reread this again. Give me a moment. It's a long probable cause affidavit. Okay, so let me ask you a question, Ms. May. Pretend there's no other drugs in the car. is the state's argument that the white substance on the co-defendant's lip and on his shorts, that that's cocaine, and that this defendant is in joint possession because the other defendant's in his car? So if we don't have the chapstick tube, it should just what's on the co-defendant. Is he in joint possession of it?
No, Your Honor, because the other co-defendant's in actual possession of it.
Okay.
And
Let me keep reading. I got to keep reading. Sorry, sir. It's going to take a minute. So the only cocaine that
Is attributed to him.
is the chapstick container.
Yes, Your Honor. As neither were in actual possession, however, both could exercise dominion and control over said item.
And Your Honor, I would just point to Pena v. State. It's 465 Southern 2nd, 1386 states that although an inference that a defendant knew of the presence of contraband, an inference that a defendant knew of the presence of contraband does not arise from the defendant's mere proximity to the contraband.
But he owns the car. It's his car.
Even if he owns the vehicle, Your Honor, because, again, everything's on the passenger side.
But it's not. The chapstick container is not on the passenger side.
The one thing that isn't.
And the vehicle is special. It's not, I believe that case like applied to like,
see what you're
if
saying.
you're at like a picnic table and there was drugs close to you, you can't be imputed to know they're there.
This is in a vehicle.
It's what?
It's in a vehicle where marijuana was in a compartment in the dash, but it was in plain view. And so the driver could actually see it was actually marijuana. But again, even if...
But he knew or should have known that the crack cocaine was in the opaque chapstick container because he owns the car.
Anything that's illegal found in your car, you're,
What?
anything that's illegal that's in your car, you're susceptible to. You're supposed to know what's in your vehicle, and when someone gets in and has something in there, we're still culpable for that.
And again, I would say clearly case law does not agree with that because we have multiple cases that just stated Pena v. State, Brown v. State, Mortal v. State states that the only difference is that it was in plain view.
Do you have anything more directly on point with this case? Because I think the only reason this court is struggling with that is there's a passenger covered in crack. The passenger's throwing it out the window. So I understand it's his car and he's responsible for what's in his car. And I think if no one else was in the car, it wouldn't be a struggle for me at all. But since the passenger's literally covered in crack, it's on his face, it's on his shorts, he's throwing it out the window, it's in the seat where he's sitting. All right. So there's probable cause that there's joint constructive possession of this cocaine that's in the chapstick bottle.
Your Honor, I would just ask that, given the facts of the case, my client can't afford a monetary bond, that you would consider an ROR.
Does the state show any criminal history after '08? Is the 2013 the last conviction?
I'm checking CCIS, Your Honor.
I got good. Okay, it's going all the way around. Oh, sorry, too much. I got carried away.
He has this current case in 2018. He had a giving false information.
Wait, what was 2018?
He had a giving false information from 2018 in Orange that was ultimately dropped.
No, I mean any convictions after 13.
2016. He had extradition in 2013. Fighting fugitive. No, Your Honor. He has arrest and fugitive warrants, but not convictions. Per CCIS, which is only Florida.
Okay.
I can't see out of state. But he apparently has history from out of state because there were 2 fugitive warrants for extradition.
It's really interesting because this says out-of-state history, none.
I don't know.
So that's not right. All right, does the state object to the ROR request?
Yes, Your Honor. Given his history, he has prior drug offenses, prior violent offenses.
When is his last drug and violent offense? Both.
In Florida, again, I don't have his NCIC. I only have FCIC. The last drug offense I see is 2009 from Pinellas for possession of cocaine, and he was adjudicated guilty.
What about violent?
Violent. If resisting without doesn't count, he had a battery, resisting, carrying a concealed, and shoplifting from 2002 at a lake.
And when? When was that?
2002.
All right. I'm going to grant the request. I'm going to release you on your own recognizance with conditions that you have to stay in contact with your attorney. You can't possess or consume any controlled substance without a valid prescription. You can't have any contact with a co-defendant or any known drug dealers. Do you understand, sir? And you know who the co-defendant is? You can't have any contact with him. All right, good luck, sir. No, there's PC. Yeah, there is probable cause, but I'm going to still grant their request. Please tell me your name.
Cherie Chantel Dew.
21 CF 12807. You're here charged with aggravated assault with a battery
Yeah.
and criminal mischief, damage greater than $1,000. What is that charge, Miss May?
I was honestly kind of concerned about it as well, Your Honor. You would think it would be an ag assault or an ag bat.
Right, or both. It is both. But I don't,
And I would argue against the aggravated battery. It was a weighted sign. I'm not sure that that would rise to the level of a deadly weapon.
it was a what?
Weighted sign.
Yeah, it says a heavy weighted sign.
I
Right,
had,
so
I had requested to.
Hold on one moment, ma'am. I'm going to appoint an attorney to represent you. Give us one moment.
Your Honor, and if you look at the arrest affidavit, he wasn't injured at all. It hit him and he stated he had no injuries.
You're not required to have injuries to have it be an aggravated battery. The aggravated battery can be with a weapon, and a heavy weighted sign arguably is a weapon.
A deadly weapon is the statute. I would argue it's not a deadly weapon.
I think for probable cause it is, because it says later in the affidavit, the weight of the sign could have caused severe injury if she hit him in the head. So I think there's probable cause. But I'm not sure if it's an aggravated assault or an aggravated battery charge. Let me pull the statute up.
Your Honor, when you pull the 784-021, it just goes to the aggravated assault statute.
Okay. All right, well, there is an aggravated assault. Well, there's probable cause for an aggravated assault. And there is probable cause for criminal mischief. All right, Ms. Dew, you can say anything you want here today, but everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am.
And the only reason we're here today is for me to establish whether there's probable cause and then give you bond. Do you understand?
Yes, ma'am.
Do you still wish to say something?
Yes, ma'am.
I would recommend you not talk about the facts of the case.
That's Ms. George, and right now she's your attorney. I'll give you a moment, Ms. George.
Your Honor, my client was just asking if you would reduce the $7,000 bond.
If I will do what?
Reduce the it looks like they put the bond at
7, yeah.
It's too high. She's currently unemployed. She just would.
That's why this happened.
Okay. She's actually relocating here. She stated she had just got off of the airplane, so she plans on staying here in Florida. I just asked that you consider reducing the $7,000 bond.
So does the state wish to be heard on that?
Your Honor, according to the information sheet, it says that she was staying to be down here for at least 1 month, but could not specify where she was going to stay. She has extensive community ties to other places. She has no Florida arrests. All of her prior history is out of state. So the state has no objection to a reasonable bond. However, she has no community ties here, and according to her interview with PTR, she was supposed to be here for at least a month.
Yeah.
This case would arguably go well past that.
I saw that as well. Ma'am, here's what I'm going to do. On count 1, your bond will be $5,000, and on count 2, it'll be $100. You cannot return to the Sheraton for any reason. Do you understand that? You have to answer out loud.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't have any contact with a victim in this case or any witness in this case. And I think that's it. All right. Good luck, ma'am.
Thank you.
Yes, ma'am. Please tell me your name.
Garrido.
21 CF 12817. You're here charged with driving while license suspended or revoked as a habitual offender and open carrying of a weapon. I'm going to appoint an attorney to represent you in this case. There is probable cause. Your bond is $2,500 on count one. It'll be $150 on count two. You can't drive without a valid Florida license. Do you understand?
I do understand.
You can't possess a weapon, firearm, or ammunition. Good luck, sir. Please tell me your name. What's your name?
I go by brother.
I'm sorry,
Refer to me as brother, please.
I need your given name, sir.
My given name is brother.
All right, do you also go by Leon Gray?
No, ma'am.
All right, did your parents name you Leon Gray?
No, ma'am.
Okay. Hold on a moment. What do we have him as in the jail?
Leon.
Have his prints come back?
Yes, they're clear.
And they came back to Leon Gray?
Yes.
All right, thank you. All right, sir, you're here on, it looks like 2 cases. 21 CF 12819, you're charged with possession of cocaine. In that case, I'm going to appoint an attorney to represent you. And give me a moment.
I would like to represent myself, please.
All right. Give me a moment to review this. All right, sir, there is probable cause for that charge. And for driving while license suspended, although it looks like they charged that in a separate citation. Give me one moment. 21 CT 6507. That's the driving while license suspended. There is probable cause for that charge as well. Sir, you don't want me to appoint an attorney to represent you?
No, ma'am.
All right, raise your right hand, please.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Okay, thank you. All right, sir, you just told me that you don't want me to appoint an attorney to represent you. Is that correct?
Correct.
Can you tell me what level of education you've completed?
Well, before I do that, can I would like to reserve my rights pursuant to UCC 1-308.
All right.
Does the court recognize my reservations of rights?
I have to look that up. Give me a moment. UCC what?
UCC 1-308.
So under the Uniform Commercial Code,
That's correct.
Your Honor, respectfully, the UCC is for the regulation and sale of goods and other transactions.
right, and I'm trying to see how that's relevant to this. That's what I'm looking for.
Your Honor, I believe it's potentially sovereign.
Oh, diplomatic.
But it's not relevant to this kind of case, sir.
I have 4 other things I would like to say.
I'm sorry, you what?
That I have 4 things I would like to say. 1, I do not consent to these proceedings.
All right.
2, Your Honor, your offer is not accepted.
Sir, there's been no offer here.
3, I do not want to be surety for this case. And 4, please bring out the bonds to show that who's going to indemnify me if
Hold
I'm
on,
damaged.
Rebecca, can you stop? Because I can't hear him. I'm sorry, say that one more time. What's number 4?
Number 4 is please bring forth the bonds that will show who is going to indemnify me if I am damaged. These proceeds.
All right, sir, thank you for that. I'm not sure that I understand what exactly it is that you want. I don't think the UCC is relevant in criminal court. I was trying to figure out how that would be relevant. I don't think that it is. So,
So you're saying this is a criminal court, correct?
yes.
So does that mean the Constitution gives us 2 criminal jurisdictions, one in common law and one in admiralty? Is that correct?
No,
Is that not what the Constitution says?
no. It is not.
Show me where the laws are in the Constitution that shows me what jurisdiction I have to defend myself under.
What jurisdiction? All right, so if you want to read the Constitution, you can do that. You definitely have rights under the Constitution. That's part of the reason I wanted to appoint an attorney to represent you, because you have the right to an attorney. But if you don't want an attorney to represent you, you also have the right to waive that right. So, do you still not want an attorney to represent you?
That's correct.
All right. Did you finish high school?
No, I didn't.
Okay, so, and you didn't go to college or law school then?
I was homeschooled.
Okay. So you understand that the state of Florida is represented by an attorney who went to law school, took the bar exam, and practices law in the state of Florida.
That's correct.
So you understand that you could potentially be disadvantaged by not having that experience.
Well, when I reserve my rights to not actually have an attorney, because
Right, you have a right not to have one. I'm just explaining to you that if you don't have an attorney, that could be to your disadvantage.
that's fine. That's understandable.
So you understand that? All right. Sir, have you ever been diagnosed with any mental health illnesses?
No, ma'am.
All right, are you currently under the influence of any drugs or alcohol or any substance that could impair your ability to understand what you're doing here today?
No, ma'am.
I see that you have a history with drugs and possibly alcohol, but today you're not under the influence of anything?
No, ma'am.
All right. And you understand that you're being charged in one case with a felony and in another case,
They're both felonies, Your Honor.
what's the Dwellis? How is that a felony? Is it habitual?
Oh, no, I'm sorry. He has an interstate compact warrant as well. I'm sorry.
Yeah, the cocaine is a felony, which is a third-degree felony punishable by up to 5 years in prison. You understand that?
I understand.
And the misdemeanor, the driving while license suspended is a misdemeanor, which is punishable by up to a year in jail. You understand that?
I'm sorry. Can you repeat that, please?
Yes, so the second charge is a misdemeanor, which is punishable by up to a year in jail. You understand? Did you say yes? You don't understand that. All right, so in the state of Florida, a first-degree misdemeanor is punishable by up to, so not more than 1 year in the county jail. And that's what this charge is that you're charged with. So you understand that's the maximum.
The other charge, what was?
It's a third-degree felony punishable by up to 5 years in prison. You understand that? I can't hear you.
No, not really.
All right, so if you're convicted of possession of cocaine, the court could sentence you to 5 years in prison. That would be a lawful sentence for that charge.
I don't understand.
All right. So given that you don't understand that, and the state of Florida is represented by an attorney who does understand that, would you like me to appoint an attorney to represent you?
No, thank you.
All right. I'm not going to appoint the public defender's office to represent him. Sir, your bond in the driving case is $500. You cannot drive without a valid Florida driver's license. Your bond in the possession of cocaine is $1,000. You are not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
I understand.
All right, good luck, sir.
Ms. Davis, is he being
Yes.
seen on the interstate compact warrant?
No.
Or is there some kind of hold for it, or?
We don't see those in IAs.
Okay.
Your Honor, Mr. Gumbo is hospital.
21 CF 12814. Ms. George, I'm going to appoint your office.
I'll waive the appearance, Your Honor.
All right, there is probable cause. I don't recall what the bond is. Give me a moment. Oh, the bond is going to be $5,000 on count 1, $2,500 on count 2. No contact with any victim or witness, cannot drive without a valid Florida license.
Your Honor, Mr. Hamilton bonded.
Hampton?
Hampton, yes.
He bonded?
Yes, ma'am.
All right, hold on a minute. Let me just make sure that his attorney is not sitting on the line.
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
All right, so
Count
his
3.
attorney must know.
Count 3 is a life offense, so that's quite lucky.
He bonded on a life offense, so somehow he had bond?
How he had bond.
That's why he bonded. Please tell me your name.
Daniel Kyle Karpwitz.
21 CF 12820. You're here charged with aggravated assault with a weapon and resisting an officer without violence. I'm going to appoint an attorney to represent you in this case. Just a moment. There is probable cause here. All right, sir, your bond is $5,000 on count 1, $100 on count 2. You can't possess a weapon of any kind, a firearm or ammunition.
Yes, ma'am.
You can't have contact with any victim or witness in this case.
Yes, Your Honor.
Thank you. You can't return to Publix.
Yes, Your Honor.
You know where that is, on Colonial Drive?
I know what they were doing. Yes, Your Honor.
All right, you can't go back there right now.
Yes, Your Honor.
And at this time, I'm going to revoke your bond in 21 MM 2523. What that means is your attorney's going to need to file a motion in front of the trial judge, okay?
Yes, Your Honor.
All right, good luck, sir.
Thank you.
Yes, sir. She's going to give you that green piece of paper that has the number to call for your attorney. Yes, sir.
Your Honor, we did Morales earlier today.
All right.
That was the one you had on your docket that we said we didn't have.
Please tell me your name.
Linwood James Mulkey, ma'am.
All right, you're here in 21 CF 12808, charged with carjacking and fleeing or attempting to elude law enforcement. I'm going to appoint an attorney to represent you in this case. Give me one moment. Give me one moment, sir.
Yes, ma'am.
All right, there is probable cause here. Ms. May, what level felony is this carjacking?
I believe it's an F2, Your Honor. I'll double check 1 second.
The allegation is with a firearm.
It's an F1, Your Honor. It's not. The victim's original story was that, however, it changed. There wasn't an allegation of a weapon.
All right, so it's just an F2,
It's an F1.
an F1. All right, sir. At this time, your bond will be $25,000 on count 1, $15,000 on count 2. You can't have contact with any victim, witness, or co-defendant in this case. You also can't possess a weapon of any kind, firearm, or ammunition. You can't return to this area, which is 1850 West Land Street Road. Any other conditions the state would request?
No, Your Honor. I believe that was the Quality Inn.
All right, you can't go back to the Quality Inn.
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Michael Ortiz.
You're here in 21 CF 12810, charged with possession of cocaine and drug paraphernalia. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? Good luck, sir.
Your Honor, Perdomo, his behavior.
All right, 20 CF 11463 and 21 CF 12821. I'm going to appoint your office, Ms. George.
I'll waive the appearance, Your Honor.
It looks like you were previously appointed in the KPS case,
Yes, Your Honor.
and I'm appointing you in the new case. Give me a minute, I got to look at what the bonds are. There's no bond on the KPS. All right, the bond on the aggravated battery with a deadly weapon will be $15,000. Count 2 will be $100,000. No contact with any victim or witness in the case. Not possess a weapon of any kind, firearm or ammunition. Cannot return to the scene for any reason. That's all. Please tell me your name.
Todd Prophet.
20 CF 557. Looks like an attorney was already appointed to represent you in this case. A KPS was issued for your arrest for failing to appear for a status hearing on charges of burglary of a structure and petty theft. There's no bond authorized. And the PD is still appointed, so good luck, sir.
What happened to Mr. Rutland?
He's next.
Oh. I was had out of order.
Okay. #21 CF 12818. Ms. George, I'm going to appoint your office.
I'll waive the appearance, Your Honor.
Ms. May,
Yes, Your Honor, given that count one is a punishable by life offense, state is asking that you hold him no bond pending an Arthur hearing.
any response, Ms. George?
No, Your Honor. Reserve the right to have an Arthur hearing.
All right, I will do that. So count one will be no bond, count two will be $1,000, no contact with any victim or witness. On count two, no return, no weapons, firearms, or ammunition.
The conditions aren't for both, Your Honor?
Well, because there's no bond on count one.
Okay.
But, yeah. All right. Please tell me your name.
Jean St. Victor.
All right. In 21 CF 12823, you're here charged with trafficking an oxycodone greater than 4 grams with a firearm, possession of cannabis with intent to sell or deliver with a weapon, possession of cocaine with intent to sell or deliver with a weapon, possession of MDMA, possession of a firearm, and commission of a felony. At this time, I'm going to appoint an attorney to represent you in this case. There's probable cause, Counselor.
Yes, Your Honor.
And does the state wish to be heard on bond?
Your Honor, I was under the impression that count one might be a life offense. I was trying to check that.
Well, it's a first.
It's a first within the firearm, I believe.
Right.
That's it.
I'll look it up too. Give us a moment, sir.
I'm not sure, Your Honor. Within the statute, it doesn't say regarding a firearm or a weapon. So I just ask that you stay the bonds.
Well, it's a first-degree felony. Isn't a weapon an enhancement?
I believe so, Your Honor. However, I don't have a statute that backs that up. Count one and count three are both first-degree felonies.
Yeah.
And everything else is an F2.
All right, on count one, your bond will be $150,000. On count two, I'll state at 15. On count three, I'm raising that to $50,000. Count four will be $150,000, count five, $150,000. You can have no contact with any known drug dealers. Are there any co-defendants in this case?
I don't believe so, Your Honor.
You can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
I believe he has another case.
Yeah, that's right, he does. Sorry, you also have a driving while license revoked or suspended in 21 CT 6509. There is probable cause for that as well. I'll appoint an attorney. Your bond is $500 and you can't drive without a valid Florida license. You understand? Good luck, sir. Thank you, I forgot about that one. We're waiting on you.
Okay, this is Watson. Silas in the hospital.
Stiles is in the hospital?
Yes, Your Honor.
All right, that's 21 CF 12816. Ms. George, I'll appoint your office.
I'll waive the appearance, Your Honor.
Okay. There is probable cause. All right, his bond on count 1 is $50,000. Count 2 is 15. No contact with any victim, witness, or co-defendant. Cannot return to, was it a Quality Inn?
Yes, Your Honor.
Cannot return to the Quality Inn, can't possess a weapon, firearm, or ammunition, and I'm revoking his out on bond cases.
And can you make sure we're appointed on any that we're not, Your Honor, just in case?
Yes, I will make sure you're appointed. So even on the out on bond? Oh, you are, okay. All right, sir, can you tell me your name? All right, Mr. Watson, you're here in 21 CF 12824, charged with possession of cocaine and resisting without violence. I'm going to appoint an attorney to represent you in this case. There's probable cause. Your bond is $1,000 on count 1, $100 on count 2. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? Is he out on bond
Yeah.
for trafficking? All right, at this time, I'm revoking your bond in 21 CF 6456. Good luck, sir. Yes, sir. Wait, get closer to the microphone.
My grandma just died Thursday,
I'm so sorry.
and she raised me. Her funeral is this weekend.
You have to get closer to the microphone.
Her funeral is this weekend. Please don't revoke my bond, Your Honor.
I have to, sir, given what you're charged with and what you were arrested for. So my recommendation to you is to call the public defender's office right away, ask to speak to the attorney who's representing you, and see if they'll file a motion in front of the trial judge. Good luck, sir. I really am sorry for your loss. All right. Anything else before court is adjourned?
Very briefly, I don't know if someone can look up his inmate number. The ASA over the weekend said it was a reset due to no PC. However, when I can't find him on the clerk site and I can't find him in our site either. An inmate number is 21022490. It's Mr. Van Cleef. You know what